Your Honor,
Yes.
for writ appeal
Your Lordship,
983 of 2024,
Date was given for today, my lords. I moved the court, my lords, on Monday. My lords, it was directed to be listed today.
What is the matter?
My lords, medical admission, my lords, for a person with physical disabilities, my lords, is denied quota. That is challenged before your lordships. My lords, though my lords, the counselling is not scheduled, it is likely to be scheduled this week. My lords, Supreme Court, the request for stay of counselling, my lords, is denied. If counselling goes on, my lords, my writ petition would become infructuous, my lords.
Monday?
May I request for tomorrow, my lords. If they were to commence with counselling, my lords, my petition becomes infructuous, my lords.
Tomorrow.
Deeply obliged.
Yes, Mr.
uh,
Yes, you want to mention?
My lordship, contempt proceedings have been filed against the contemnants, my lordship. It would be much
Order.
obliged if it is heard at the earliest, my lordship. Contempt petition, my lordship. It was filed before this honorable court, my lordship. It has been
You filed it.
disobedient, my lordship.
What do you want?
It will be listed at the earliest, my lordship. To
It
be
will
heard
be
at the earliest, my
Once
lordship.
you remove the office objection, it will be listed.
All complaint, my lordship.
No need to submit memo.
Much obliged.
Your Honor, for WA 983 of 2024, intellectual property rights classification, I am presenting a memo for posting, for it to be presented in the, posted for hearing in the appropriate court for tomorrow.
You go before the register.
Your Honor,
If it is posted for before approved court, go before the register judicial, not before the court. It is
no,
a matter to be dealt with.
I'm actually appellant party in person representing myself,
You may be
and
party
it has to be
person or-
posted for hearing in the appropriate court. So
For
I was told-
administrative orders, you don't mention before the bench, you go to the register. Yes.
If the lordship kindly, it is one matter, PIL matter, to unveil the mystery of 16,000 acres of Bhudana lands in Karnataka state. My access is based on the research report of the Dr. Nimisha Suklam and the Sudarshan Iyengar of the Gandhi Dham University. I request your lordship to post this matter.
What is
At
the
very convenient
urgency?
date.
What is the urgency? What is the urgency?
Urgency is some response that try to create the third party interest in the public largesse.
What is saying?
No, PIL case, writ petition is.
PIL, no urgency, yes.
Writ appeal, my lord,
You
education.
remove the office action, listed within 5 days. Yes.
My lord, writ appeal, my lord, education matter, my lord, 6, 7, 8, 9 student, my lord. Modification here to be filed, my lord. 632 is writ appeal order, my lord. One line correction, my lord. Recognition liberty, one line mistake, my lord. Modification tomorrow, my lord, matter urgency, my lord.
What is the urgency?
My lord, student not to admission, my lord. 6, 7, 7, 8, 9, 10, my lord.
Admission matter.
Admission not.
So it is a writ appeal.
Writ appeal, my lord, education matter. 8, 9, 10, my lord.
Correction in order. Tomorrow.
Tomorrow.
If I may, Your Honor.
Tomorrow, correction at 11. It is posted.
80-year-old woman directed back wages, 7 months there has not been any compliance. It's a question of sustenance. Latest UGC pay guidelines are not being met. I'm moving contempt, my lords.
Contempt,
Contempt, non-compliance of final order of single judge.
5th of August.
My lords, we'll have it next week, my lords.
I'm already complied the office. I'm already complied the office objection before the vacation, after vacation, my lordship, before vacation. This is not yet listed, my lord. Some urgency, my place, some other person will be appointing that is the reason, some urgency is there.
Office objection complied before
Already
vacation.
complied, my lord.
Before vacation.
Before vacation.
And the matter is not posted.
Not yet posted,
If you turn out to be wrong, then what?
my lordship.
If you are wrong in your statement, then what will follow? Every matter which is mentioned before this court, saying that the office objection are complied before 6 weeks or in March and not posted, has turned out to be wrong.
Lordship, I am submission also given to this, some council submission also given to me.
Because no matter where office objections are removed is lying unlisted. It is immediately listed once you remove the office objection. Give the number, we'll verify. If it is you are right, then it will be posted on next week.
If I may, Your Honor, I am here for respondents in writ appeal 2/8/2023. I have filed an application for modifying the interim order. The interim order was obtained by suppressing certain facts, and which I have brought out.
Interim order regarding what?
Regarding, Your Honor, the single judge passed several directions
What
One
is
of
this?
which is the receipt of aforesaid dues by the laborers is without prejudice to their right in various claims before any
Tell
competent.
rather than reading, tell what is about, what it is about.
Your Honor.
Instead of reading, tell what is the interim order, what is the subject matter of interim order?
Your Honor, the contract which levied 6% penal interest.
No urgency.
Your Honor, the laborers' rights are being affected in the industrial tribunal. Kindly have it tomorrow, Your Honor.
12th August.
Huh?
12th August.
Tomorrow or Monday. Your
Then
Honor.
don't mention, we listed earlier than what court gives the date. Tomorrow not possible, yes, madam. Get it listed, the matters wherever we go, with the, even if the memo is not accepted. Yes. Yes, madam.
Serial number 34 today, my lord, it's pertaining to the university.
Rajiv Gandhi. will
That's
take.
not only the request, my lord. What has happened, I was sending emails as well, my lord, with respect to, like, the counseling starts, my lord, the admissions to the new colleges will be without affiliation. Without, we have not granted them affiliation, the new colleges have got the file, because there's no body functioning, we are unable to do anything. And they're all sending emails and pressurizing us to give affiliation without doing any inspection or without doing anything. They are telling follow it next year.
We'll take up today.
Today, first half.
May I please your lordship?
If it doesn't reach in the first half, second half.
May I please your lordships?
Yes, Mr.
If I may please just quote. This is a PIL matter challenging the constitutional validity of the Karnataka state employment of local candidates in industry, factories, and other establishments bill 2024, otherwise known as the Karnataka Local Candidates Reservation Bill. Now, this is a PIL matter. I would like to move it on. It came to be filed on 19th of July. Office objections were removed on 22nd and today is 24th at an appropriate date. At,
6th August.
My make.
Memo for posting of day in case of 13/024.
May I please your lordships? My counsel is
Wait,
available.
once the physical mentioning is over, we'll advert to you. Yes. Yes, Mr.
My lord, this is memo for posting, my lord. This is restoration of petition, my lord. This was dismissed due to non-compliance of the office objections with a bona fide intention. Earlier advocate, he was remained absent on the day due to the non-compliance, non-appearance of my advocate. It was deemed to be dismissed. Hence, this restoration petition, please kindly list in the next week, my lordship.
Next week.
Next week, my lordship. Please, ma'am.
My lord,
May I make one submission, my lord?
Writ appeal 929 of 24, my lord. We have filed, my lord, it is an association of the apartment, my lord, where we are unable to collect the maintenance from the rest of the residents due to the order passed in writ petition, my lord. One of the resident has got stay for non-payment of maintenance. For the reason, even the 1,850 flats or something, like that, they are unable, we are not able to collect the rest.
You will be wasted once you remove the, yes,
May I
madam.
make
My lord,
one sub-
it's a very
My-
emergency, my lord.
Not by memo, it will be listed.
May I permit me to make a submission, my lord? That's in.
Yes, madam, you want to mention?
With your lordship, my lord, mine is adjournment, so I'm waiting if anybody wants.
Adjournment, I'm making the adjournment, my lord. Seal number 28, my lord. My senior counsel, Mr. DL and Rao is not keeping well, is admitted in the hospital.
28 is that,
I've already informed to the learned counsel for the government advocate, Mr. Mahendra.
it is that group.
Group matter, my lord. We have moved the application before this honorable court for seeking the direction to issue a mineral permit. Therefore, they have filed the application, they have
Today, my lord, the whole group is not listed for hearing. Only one
Only
matter
one
they have
matter.
filed IA.
in our matter, my lord.
So when do you want?
Kindly have it in after 2 weeks, my lord. It's have my senior is hospitalized.
8th of August.
Please, my lord. Much.
Lordship, serial number 37, lordship. I pay for a short accommodation.
Wait,
Yeah,
one
to-
sec.
I am for the complainant.
Lordship, the translation is.
Serial number?
37, lordship.
When accused number 1 also, direction was issued to the accused number 1, deputy commissioner. They have also not filed any objection, my lord. Any short date may be given. My land is used for the public use. and
Then you
compensate.
are seeking time. So when do you want?
2 weeks time.
12th of August. At the request of learned advocate, Ms. So and so for the respondent. Send over to 12th of August. In the same way, in serial number 28, at the request of learned advocate, Mr. So and so, on the ground that the senior counsel who is appearing on behalf of the petitioner is in indisposed health.
With your lordship, serial number 33, my lord.
This
Wherein they have filed two interlocutory
33.
applications for none, which I need to file reply. It-
I appear, my lord, in this case.
And the other side is also there.
My lord,
Lord, I appear, my lord, for the appellants.
Senior counsel is there, man.
Yes, Mr. Nagan.
My lord, I don't want to oppose an adjournment, my lord. My only anxiety is this. Your lordships may recall this is the matter relating to BBMP and the PF demand.
Correct.
I'm only apprehensive that they should not start any other proceeding for levy of penalty and damages. Because your lordships had
Who
issued
appears?
notice.
You are
I appear for the RPFC,
so-
Provident Fund Commissioner, but I think that it has been already initiated. Now I do not know. If they have not initiated any proceedings with
then
regard to
don't-
penalty, then I will not initiate. We will not initiate.
Don't.
Don't
precipitate.
pass an order.
Really?
That's my request.
Don't
Yes,
prec-
yes, yes, madam. We will not precipitate on the pending
So they will
proceedings.
not precipitate anything.
Grateful, grateful.
No coercive steps.
Please, my lord,
Please,
please, madam. 2 weeks time for filing objection.
13th of August.
My lord,
Very
let it be recorded, my lord.
Number 16.
At the request of learned advocate, 13th August. Shall we record that? there will be
Yes,
no
my
pre-
lord, it may be
Yes.
recorded, my lord.
Shall we record that there will be no precipitation?
Yes, my lord, your lordship may kindly record.
We can record?
Yes, that I will not.
In the meantime,
precipitate.
there shall be no coercive steps
Yes,
by the Provident Fund authorities.
Provident Fund authorities and my submission.
My lord,
My lord,
serial-
Great.
serial number my
Okay.
lords. Serial number 16, my lords, I'm appearing for the
Serial
petition.
number
16, my lords.
16.
16, my lords. I'm appearing for the petitioner in that case, my lords. The arguing counsel has some personal inconvenience. She's unable to
13th
appear
August.
before this order.
13th August. Same at the request of learned advocate.
May I request next week, my lords?
No Parna,
Please, my lords.
Bordoloi. On the ground that the senior counsel appearing with her has personal difficulty. Yes,
Lord, serial number
That's
15, my
serial
lord.
number 26.
Serial number 15, my lord. Concerned,
26,
the concerned
20.
advocate relate to expired.
26.
26, my lords.
Yes, what do you?
I'm the amicus appointed, my lords, for the
This is
complainant.
criminal contempt is how? Criminal 26 is not here. Acha, yes, sir. What do you want?
I am the complainant, my lords. I'm the amicus for the complainant, my lords. The complainant is unwell today, so kindly adjourn.
26, I appear for the.
So it can go to 19th of August,
My lords,
19th August,
please, my lords.
19th August.
Lord, serial number 15, my lord. Concerned advocate.
You want to mention? Yes.
Serial number
57.
57. In line, we will not break the line. 57. What do you want?
Looking for short accommodation.
13th August,
Interim order should be extended.
interim order to be extended over to 13th August at the request of learned advocate for the appellant. Interim order already granted, shall continue to operate till the next.
Serial number 31.
Lord, serial number 15, my lord.
15.
15. Concerned advocate relative expired, they have gone to send funeral. Therefore, I am seeking one this time.
Why you are seeking time? Why you are seeking time?
Yeah, no. And also this matter engaged, my lord.
Why?
He is also out of state.
Why you are seeking time in Silma 15?
Not the concerned advocate relative expired, my lord. He has gone to Ballari. Therefore, I am seeking.
1st August.
Serial number 31.
Of the personal difficulty. In view of the ground of personal difficulty of the arguing counsel, advanced on behalf of the writ petitioner, stand over to 1st of August.
Serial number 31, my lords.
Madam, serial number 55, my lord.
55 here.
My senior having some inconvenience, my lord. I pressed to it.
Inconvenient.
It's
Why?
2 weeks time.
Why inconvenience?
He's out of station. Some person inconvenience went out of station.
Who?
My senior, no. My senior, Kalyan R. I'm for appellant. No. Kalyan. R.
You are not counsel.
No. I'm his junior.
You are also counsel. You have difficulty. You have difficulty in arguing. What do you want, mister? What do you want? Time,
Time.
argument, dismissal? Then it can be readily written.
No, adjournment. 2 weeks time.
2 weeks again. At the request of Learned Mr. You are Kalyan. You are Kalyan.
Yes, sir. Kalyan R.
The request of Learned Kalyan R for the appellant stand over to 22nd August. Yes.
But serial number 31, my lords.
You want to mention? Yes.
See,
Same.
No, my lord, it's a different.
Yes.
Serial number 46, my lord.
46.
It is a similar complaint petition was filed and it was disposed of by this honorable court, my lord. I had asked for the same relief. So if an order could be passed with the same thing, my lord, can I pass on the judgment?
Let it be called out.
serial number 31, my lords. I am for
31.
the appellants. I informed the other side. I have some personal inconvenience. Can be taken after 2 weeks, my lords.
31. What is it about? The writ appeal of 23, 2nd August.
Obliged, my lords.
I'm apologize. In serial number 55, interim order is there.
We extend.
Which one?
Contempt proceedings, my lords, fresh matter pertaining to promotion. Maybe kindly take.
To be listed, not by memo.
Obliged.
Once you remove the office objection, it will be listed.
Yeah, Your Honor, for writ appeal for 2024, I'm told that this honorable court is the court to be where it will be heard. So I would request that it be posted for hearing here tomorrow. I would take about 10 minutes to introduce the writ appeal and then adjourn it.
It's fresh up.
Fresh writ appeal.
Agency.
I'm expecting the consent letter according to this honorable court's orders anytime now. So I want the subsequent interim relief that is listed in the writ appeal to be ready to be granted as soon as I receive the consent letter from the respondent, according to the court's orders.
What is the subject matter?
The subject matter has got to do with breach of Patent Cooperation Treaty, Article 18, Clause 2, and Article 19, Clause 1 by United States Patent and Trademark Office. So I have requested this honorable court for orders for issuing of the consent letter to the respondent, the Authority Legal and Treaties Division of Ministry of External Affairs to issue the consent letter to sue United States Patent and Trademark Office, and also summon World Intellectual Property Organization
31st.
to
31st.
Your Honor?
31st of July. Yes.
Could you give the date again? 31st July.
Serial number 108 is the party in person filed WA 16 number 16/54 2023. This is listed in last fifth time, but not here. Is the third and after.
Little louder, little clear. What do you want to convey?
This is the three.
Speak louder and clear.
The office objection of raising.
108.
108.
4 weeks time is granted to remove the office.
My lord, the office objections are three office objections, right? But both first and second, their documents I have lost. The documents I have. That's why.
So want to convey to court master. Yes. To convey to court officer, whatever you want to convey. Yes.
Any mention through VC, sir?
Milords, we just wanted to express our gratitude. Our local council has already mentioned it before your lordships today morning.
Which one? What you are mentioning?
This was regarding restoration application. Our local council has already mentioned it, Milords, and Milords have allowed it for next week. We just wanted to express our gratitude.
Where is your colleague?
Milords, he has already mentioned it and he has submitted a memo. I think very well, Milords.
Your Lordship, serial number 48.
Yes.
I'm appearing on behalf of respondent number 8, Your Lordship. I need a short accommodation. I have to file statement of objections. I've informed the petitioners also.
You informed or you are going to inform?
I have informed Your Lordship.
What is your good name? Learn and educate Miss.
Swati Ashok, Your Lordship.
For the respondent. Acha, this is will grant you the short time,
Yes, Your Lordship.
30th July.
Yes, Your Lordship.
At the request of learned and advocate so and so, the respondent, who stated that the petitioner has no objection to her seeking time from a standover to 30th July.
Much obliged, Your Lordship.
But if you proceed on 30th, yes. Proceed on 30th July. Yes. Then okay.
So list number 2, number 1, Shajay Kumar Patil.
Hearing, my lord, for the petitioner. This is the matter relating to, in fact, now the apex court has ruled out, my lord. Yesterday, I am told, cancellation of the NEET examination. So the counseling, therefore, there is urgency, my lord, and I have sought for an interim relief that I should be considered for counseling under the Hyderabad, Karnataka category for the general seats, not for the reserved seats at all. And they have filed their objections also. So my respectful submission is, my lord, I have produced the seat matrix also, along with my IA, which I have filed, my lord, where I have sought for a direction. This seat matrix, my lord, pertains to the academic year 23-24.
Is it PIL?
No, not PIL. Private interest, petitioner.
I make one
Individual.
submission before my learned friend commences. I'm told, my lords, that the issue is being actively considered by, in fact, last occasion also that submission was made, that the cabinet subcommittee is considering it. Now, I think because of the assembly session, that decision is still yet to be taken. Now, this matter need not be heard if the subcommittee agrees with the petitioner and reservation is given. But I'm also told, my lords, I understand my learned friend's anxiety that the counseling may begin. The KEA informs him, my lords, that till end of next week, possibly there's no counseling. So lordships may have it next week. If a decision is taken, then there ends the matter.
May I make one submission, my lord? I have verified, my lord, what the cabinet subcommittee is considering is regard to the general OCI students, whether they are entitled to be given. For that, my lord, KEA is felt as it. I am claiming, my lord, Hyderabad, Karnataka, that issue is not before the cabinet subcommittee.
We do not know how to.
That is what they are saying, what we have understood. They are only saying, my lord, let them say which is the issue which is before the subcommittee. Because they are saying.
They will come out with the decision of the committee.
On the OCI, kindly see Annexure B.
Lord.
Annexure B, may I just point out, my lord, how? Annexure B at page.
The process is going to start.
Page
when?
37. Page 37.
Process is going to start when?
The council.
The central government has to issue a revised rank
Test
list.
dates, in view of the Supreme Court.
Yes, in light of yesterday's order.
All India quota counseling should get over. Then we will start.
There's still some time.
In 1 week, nothing is going to happen as
True,
far as
but
medical.
then the anxiety would be, my lord, even if, my lord, there is an interim order, which I am assuming, my lord, if an interim order is passed, my lord, there is some urgency in the sense that we will have to go to the KEA in the back room, my lord, manually. The whole thing system will have to be changed because the system now does not even permit me to participate in the counseling.
Mr. Passing of any interim order will be interjecting the process of consideration.
And there's
by
no
the
ranking also.
No, I'm not, no, with due respect, my lord, all that I am seeking is counseling should go on. I should be considered for counseling.
interjecting the decision which may be taken by the subcommittee.
No, may I make,
True. May I just make this submission, my lord? There is already a judgment of the apex court, my lord, which is both binding on the Karnataka government as well as this honorable court. Now, what is the subcommittee is going to take a decision contrary to the Supreme Court judgment? What is it, my lord? The issue is whether they have to comply with the Supreme Court judgment or not, whether the OCI candidates are eligible to be considered for counseling in the general category. Now, they have already given an undertaking before this honorable court, the KEA as well as the additional government advocate in the next matter also, and in this matter also, my lord, I have produced the judgment. They have given an undertaking as far as OCI candidates are considered, they will be considered in the general category. So 90% of the distance has already been traversed. Now, subcommittee, my lord, cannot go back as far as that is concerned. They cannot say that OCI candidates will not be considered for counseling on par with Indian citizens in the general category. Now, the next issue is whether, in this case, my lord, the petitioner, who, my lord, has studied in the Hyderabad, Karnataka region, her parents both have studied for entire education in the Hyderabad, Karnataka area, who satisfy the definition of local persons under the presidential order, whether this petitioner, my lord, while being treated on par with the Indian citizens, can ask for the seats of the general category in the Hyderabad, Karnataka, general category. No, not a reserved seat at all. That is why I have produced the seat matrix. In the seat matrix, there are 393 seats for general category. There is SC/ST seats, which is separate. Other OBC reservation, which is separate. Kindly see the IA, which I have filed, my lord. May I just point out that, my lord?
We will wait for when the decision is likely.
The same submission was made on the previous occasion, my
No,
lord.
I understand, Manoj, but I think hopefully by end of the week, early next week, if, in fact, the Learned Advocate General also is in touch with the concerned ministers, Manoj.
Today is what?
Today is Wednesday, Manoj. I think by Monday
24th.
or Tuesday,
31st.
Manoj may have it on, yeah, very well, on Wednesday, Manoj.
31st.
31st will.
Milord, one submission, Milord. I am for respondent for Union of India in this case. Actually, in the regarding to OCI, a new review petition has been filed before the Honorable Supreme Court of India. So even that is, the hearing is there today itself, Milord. So based on that, we have to file.
We've come back to 70%.
We have to file.
If the review is allowed, all OCAs will go out.
We have to file our.
If the review is
objections
allowed.
also.
Review petition is this judgment.
Yes, that.
Apex court judgment.
Apex-
Anushka Renguntanwal.
Yes,
Anushka Renguntan.
That is.
I have produced that judgment along with my writ petition. At page 93.
Even as learned advocate for the petitioner, in both matters, Mr. Ajay 1 and 2, separate both. Even as learned advocate of the petitioner, Mr. Ajay Kumar Patil, rest for grant of interim leave, for considering the grant of interim leave, comma, in view of the fact that the developments pursuant to what is observed in order dated 11/7/24 are awaited for the culmination. And also in view of the statement made by learned advocate Mr. Ramesh that the counseling is unlikely to begin.
Yes. As far as medical is concerned.
Medical, because engineering, my lord, is likely to come in.
Counseling for medical seats is unlikely to begin within 1 week.
Yes.
From a standover to 31st.
For consider, my lord. This is the second time, as a finally, my lord, for consideration of interim relief. That is all that I am seeking, my lord, because again and again, if they keep on asking time, my entire writ petition becomes infructuous. And I lose an academic year. I
will not permit it to begin.
Please, my lord, that is all that. That is my humble request.
Obliged.
In fact, in serial number 2, there is an interim order where I have been directed, the court has directed them on the basis of the undertaking given by the additional government advocate that will be considered on par with Indian citizens for the general category.
There is no reservation issue.
There Hyderabad, not a reservation. Hyderabad, Karnataka issue does not arise in the second matter. Both the matters can stand over.
Common order. We are passing common order in both.
Please, madam.
Next one. This contempt matter, still number one. Mr. Ravi HK.
I appear for the petitioner in this matter, my lords. Lord, this is a matter wherein the Bangalore Development Authority had earlier passed an order to remove certain illegal structures in the Rajajinagar suburb area. However, the said order was not implemented. Subsequently, my lord, a writ petition came to be filed. Wide order dated 7/11/2023, my lord, at page number 18. The learned single judge directed the Bangalore Development Authority to implement the order within a period of 3 months.
Notice
Till date, the order is not implemented.
7th August. Notice 7th August.
Much obliged.
This is number two. AJ Srinivasan.
With the petitioner, my lord.
Notice returnable on 12th August.
Number three. Muni Krishna.
For the petitioner in this case.
Notice returnable on 12th August.
Number four. Srinivas K.
For the complaint appointment on compassionate ground, Lord, was rejected by the accused, which came to be set aside by the Sambu Court, Lord, wide annexure at order. Annexure D, my Lord, page number 43.
Notice returnable on 19th August.
Please.
Number five. N. Sriram Reddy.
Lord, this is second round of litigation, contempt proceedings. Kindly go through page number 23, my lord.
Take instructions in this matter. We're coming for the first time.
So this is second time
Yes, sir.
contempt petition is required to be.
Yes, I've informed the authorities.
Notice written on 5th August, learned additional government advocate shall take instructions in light of the fact that these proceedings are a second round of contempt litigation. First of, despite earlier order passed on 1st April 24 by the division bench in the previous contempt petition, the directions are yet to be complied with. Then say notice returnable and then say the learned additional government advocate, Mr. Jafar Shah shall take instructions.
This is number six.
Kindly give
Virupaksha
the
appeal.
date, 5th August, 5th August.
Number six.
Notice returnable on 12th August.
Seven.
Similar matter.
Virupaksha PH.
The similar matter.
Same. All.
This is number eight. The Sampath A.
Annexure page number 8, my lord, the annexure page number 8, my lord, the order. To consider the representation to effect the kata based on the civil code decree, my lord, wherein a suit for specific performance has succeeded, my lord, the Ternate court has executed a decree. Based on that, I sought, my lord, the effection of revenue entries. The representation was given, my lord. But the Tahsildar, my lord, the annexure E typed copy, my lord, at page number 30, translate copy of 35. Please.
Returnable on 13th August.
This is number nine. Mr. Vasant Kumar HT. Still number nine. Mr. Vasant Kumar HT.
Not. Keep it.
Number 10,
This
So,
one
Anil
was put
Kumar?
directed after setting aside the seniority list. First determination of the eligibility date in the feeder cadre is required to be done. That is refused to be done, my lords, by the state government. At the page, the direction is at page,
Notice 19th August.
Seniority list has been,
this is number 11. Mr. Satish K.
Notice 19th August.
Number 12.
Notice written never.
Number 12, sumo to writ petition PL.
Here for the state. I pay for the BBMP members. It says a sumo to PL initiated by this honorable court regarding spread of dengue.
Dengue, so sumo to PL dengue case, my lords. Increase in dengue cases in the state of Karnataka. The lordships had ordered suo motu cognizance of the issue, so we filed the petition. It was for the BBMP and state to reply.
We have filed our status report, Lord. First, the BBMP members. BBMP as well as the state.
we take up at 2:30. Please, 2:30. In fact, we filed a detailed report, my lords.
We'll consider.
Number 13, Mr. Satish K. N.
For the petitioner in this case, my lord, a week's time may be granted, my lord. A week's time may be granted. That council is not feeling well, my lord, today. Next week, my lord.
House is not in order.
Sorry, he's not feeling well, man.
You are not feeling.
No, not, I am not, my lord. That Satish Kane. I'm not Satish Kane.
Who are you, but yes.
I'm,
RTA detective.
yes, my lord, petitioner.
When do you want?
Next week, my lord.
1st August.
Please.
As requested on behalf of the petitioner. From extend over to 1st of August.
This is number 14, Mr. Srikanth P.
If I may please this court. I'm here on behalf of a petitioner who is a pregnant mother challenging the increase in the price of milk which is sold by the Karnataka Milk Federation, which is respondent number 2. On 26th of June, the respondent has increased the price of milk by 2 rupees across various variants. I will delve into the different variants which are sold by the respondents. It is strangely accompanied by 50 ml increase in the quantity. Now, this has not been the history of the respondents at all. They have increased prices in the past, which is in 2022, 2023, and this is a third increase in the past 18 months. So it has happened that 50 ml is being given at 2 rupees. Now, there are 3 limbs of argument which are coming up. One is, of course, the arbitrariness, which I'll canvass in the first part. If 50 ml is available at 2 rupees, and there are 7 variants which are available which are sold by the respondent, which is wide annexure A in page number 30, my lords. There are 6 variants on in page number 30, and then one more variant within page number 31. Of course, buffalo milk has been discontinued, which is the second last variant, and then the desi cow milk has been left untouched. I'll touch upon that particular aspect as well. In the 7 variants, the prices of the 7 variants are available in annexure C, page number 32. It is quite evident, if your lordships are with me. If your lordships are with me, this is page number 32, annexure C. If your lordships may refer to the table, which is there of the Karnataka prices, revised prices after hike. The first table, Nandini milk variety. Which is annexure C. I may continue. Annexure C, page number 32. If your lordships may turn your attention to the table, which is a Nandini milk variety and the revised prices after hike. From 43, it goes up to 57. The price of milk goes from 43 to 57. So if 2 rupees is being charged extra by the logic of the government, or by the logic of the government and the KMF, the government is speaking on behalf of the KMF in this particular case, where the Chief Minister is issuing statements. By the logic of the government, they say there is no price increase. 2 rupees is for the 50 ml milk. That necessarily translates to 100 ml at 4 rupees and 1000 ml at 40 rupees. So what is happening over here is the poor people who are consuming the lowest quantity slash the lowest quality, which is 3.5, it is dependent on the fat content of the milk. They are being given extra price, extra milk at 40 rupees per liter, and the highest quantity is receiving the same 40 rupees per liter milk when the price is 57 rupees for them. Now, this is resulting in arbitrariness, which is manifest from this particular price increase. That is number one. Number two, the respondents there are two categories of milk which are sold. This is the category, 7 categories of milk which are sold. Then there are two quantities that are sold, 500 ml and 1000 ml. The respondents have increased the quantity of 500 ml by 50 ml, given it 2 rupees, 1000 ml by 50 ml and given it another 2 rupees. Now, essentially what is happening is 1000 ml consuming consumers are left with a lesser quantity of cheaper milk. So if 40 rupees is the price of milk and the government is giving me a largest, the benefit is being percolated to the highest premium variant, which is being consumed not by the poor people, but by the people who can afford. So that is the second. There seems to be no reasonable nexus between the price increase and the rationale for this particular price increase. That is my second argument for the limited purpose of admission. The third argument that I would like to canvass is there is no intelligible differential. In a packet, I cannot differentiate between two quantities, 500 ml being charged at 43 rupees to 57 rupees. Second is 2 rupees for the 50 ml, irrespective of the various variants. Now, can a consumer differentiate? Of course, the consumer may be benefiting. It may be said that the consumer is benefiting. Can a intelligible differential be made out prima facie from this particular price increase is a question that I would like to canvass during the course of these arguments, my lords. So, to me, for the limited purpose of admission of this particular case, it seems squarely within the Article 14 regime, which the courts have held in the past as well. Number one, Milords. Yeah, my lords. The procedure of distribution of state largesse must be transparent, just, and fair. It can be argued that there is largesse given by the state by additional milk at a cheaper cost. However, the benefit should percolate to the poor and the needy, which is at the lower variant, which is at the lower. It is an inverted pyramid, my lords, where the rich are benefiting and the poor are being. There seems to be no reason for this particular. The question of the reason for price increase is not forthcoming. There is no public study. There is no commercial. The point being, the commercial mind or the commercial study being conducted for this particular price increase, and it is a one-in-a-lifetime price increase that has happened. One-in-a-lifetime price increase with a corresponding price, with the corresponding increase in the quantity that has happened in the history of the respondents. So, in my humble submission, my lords, this is clearly a case of an Article 14 violation, which requires a thorough examination by the respondents, by the state, which is giving statements on behalf of the respondents, which respondent number 2. It is my humble submission.
So this is which number 14? Third learned advocate, Mr. Srikant P. for the petitioner. Sorry, you are appearing?
No, for respondent number 1.
And learned additional government advocate, Ms. Nilokar Harper, who appears on behalf of the respondent state upon service of copy of the petition in advance. Who are you? Petitioner.
Petitioner Amrita Lakshmi, Dr. Amrita Lakshmi R.
That we know. Who are you?
I'm Srikant P.
That is also we doubly know. Who are you? The petitioner happens to be a chartered accountant and claims to be a public spirited person who has filed his petition in the nature of public interest petition.
Petitioner, sorry.
Seeking a prayer to direct the respondents to recall the price increase in the milk products. In the price increase for milk until measure is worked out for pricing at arm's length for all the quantities of packets. Full stop. The case of the petitioner is that the respondent, respondent to Karnataka Cooperative Milk Producers Federation Limited, publicly announced on 26 June 24 about hike in the prices by 2 rupees across all the product ranges of milk. It is stated that the respondent to sells and markets the milk and milk products in the brand name of Nandini, which are the product of household consumption. It was stated that while increasing the price by 2 rupees for all the products, the quantity of milk provided in the packet is increased by 50 millimeter. The contention paragraph is that irrespective of the size of the pack, the increase of ₹2 is provided for, which results into extra cost for all variants, including the variants where the basic price would be different. Paragraph. Vehemently raising grievance against the price rise as above for the milk product. It was contended that the price hike has to be borne by the poor consumer who consumes the lowest variant of the milk and milk products. It was contended that the move by the respondent number 2 Federation in hiking the price is against the commercial wisdom and operates contrary to the tenets of Article 14 of the Constitution. It was further submitted that the state of Karnataka alone has the pricing mechanism of such nature and that the increase in the price is not rational. It was claimed that the price hike is not transparent. Paragraph. The determination of prices of product in any area, which may include the milk and milk product, and the pricing policy in that regard. Cannot be a matter of consideration in public interest litigation. Full stop. It is tried that the pricing policy is essentially in the policy domain and judicial review power would not be normally exercised in respect of such decisions unless the decision is shown to be palpably wrong or against any statutory prescription. Paragraph. What price is to be fixed and determined for any product, including the milk products, is to be guided by host of considerations which are commercial in nature. The commercial wisdom of respondent 2 in taking decision to raise the price by 2 rupees for every product would not be a matter of consideration by this court in public interest litigation. This court would not substitute the commercial wisdom in the area exercised by respondent 2. Pricing is a expert decision and as stated above, depends upon variety of factors. In the present case, while increasing the price by 2 rupees, the respondent federation has provided to give 50 millimeter quantity of milk, additional quantity of milk. Be that as it may. Paragraph. The court is not inclined to entertain the present public counsel litigation for the reasons stated above. Accordingly, petition is dismissed.
Number 15, 16 are urgent. Number 17. Nish Jose Anthony.
Here for the
17.
appellant's minutes. Here for the appellant's minutes.
Where is your opponent? Keep,
Here, my lords.
keep back, child. Next. Did you raise the point of maintainability before the single judge?
Yes, my lord, it was in fact considered. It was considered in page number 30 running the issue.
Yes. Number 18, writ appeal matters.
Yes, case not.
Natarajuti.
There are four, totally, my lord, there are four identical matters, my lord. In the previous hearing, my lord, the identical matters, my lord, were heard. My lord, directed to, my lord, connected this matter along with those appeals, my lord. I am filing, my lord, the memo.
Be connected. To be listed with writ appeal number so and so as per the memo submitted. The appeals may be listed on 13th August. It is regarding what? Number 11.
Number 19. Mr. Nandish Goda.
Appearing for the appellate, my lord. This is a connected matter. I may permit it to pass.
What? Everybody says connected.
I may permit it to pass the judgment.
So here which order you are challenging?
Writ appeal already dismissed it, my lord. Connected matter 1499 of 22.
Same order. First. There's a common order in two writ petition. Learned advocate, Miss, what is your name? So and so, so and so. Clearly stated that the order impugned in this writ appeal was common in writ petition number 59788 of 16 and writ petition number 59790 of 16. It was stated that writ appeal number 1499 of 23. Insofar as it pertained to writ petition number 59788 of 16. Came to be dismissed by this court as per order dated 30th May 2024. The said order dealt with the very impugned order, dealt with the same common impugned order. Post of the order passed in writ paragraph, order passed in writ appeal number 1499 of 23 reads as under court. Post of the aforesaid order will apply to the present case accordingly. The appeal is dismissed. Please.
Number 20. The Tyagarajas, yes.
No, for the appellant in this case, ma'am. The appellant has before this honorable court challenging the cancellation of his appointment order by the respondent. Has preferred the writ petition, my lordship. The writ petition is disposed of with a direction to the both the parties to agitate their grievances in a criminal case. The relief claimed by the petitioner in the writ petition, my lordship, is to set aside the impugned order of cancellation of order of appointment by annexure A in the writ petition. The first respondent is the board, has invited application for selection to the and appointment to the post of assistant. Pursuant to the recruitment notification, the appellant has applied for the same and he has been selected and appointed. After following the due procedure, lordship, the appointment order has been issued on 11/6/2020. Subsequently, he was called for production of original his testimonials documents for verification. He has produced the same before the before the respondent for verification. The same have been forwarded to the concerned university for verification. The concerned university has gave opinion about the genuineness of the documents produced by the appellant. Therefore, there is no bogus or forged documents have been produced by the appellant.
Investigation by the police was general or in respect of your case?
In respect of my case, the police have submitted their C report, my lordship. Against the C report, the respondent has filed.
What is this 86 of 21? Same. What can be done in this appeal? What can be done in this appeal? Nothing can be done.
My lordship, because I have not produced any fake or concocted documents in support of my.
That is the matter of investigation. And the-
Investigation is already completed. The C report is also filed, my lordship, that they have responded,
it
have
is not
preferred a
not
protest
com-
memo.
Not completed.
No,
Yeah,
yes,
they-
my lordship,
they-
I have, the respondent in this investigation is completed, my lordship. Completed.
Matter is pending before the court.
Protest, they have filed a protest memo against the C report.
It is pending.
They have
Yes,
filed-
my lordship, because as could be seen from the investigation, my lordship, I have not committed any misconduct.
We can't set it out their objection and
My lord, the whole thing is completely fabricated.
Lord learned advocate Mr. So-and-so, and for the appellant and learned advocate Mr.
BL Sanjeev. BL Sanjeev.
Little loud,
BL Sanjeev.
BL Sanjeev man.
BM,
BL Sanjeev.
BL Sanjeev for the respondent board. The challenge in this writ appeal is directed against judgment and order dated 22nd June 2020 of Learned Single Judge. So, thereby, Learned Single Judge, taking into account the pendency of the criminal case being crime number 86 of 21 before the competent court, has refused to entertain the writ petition of the petitioner, observing that the competent criminal court shall endeavor for early disposal of the said criminal case. It was observed that the petitioner has already been relieved from service, relieved from office, as per order dated 6/1/22. After his 6/1/22 paragraph. In the background, it was a case put forth by the petitioner that pursuant to invite of applications by the respondent water supply board, water supply and sewage board, the petitioner applied for the post of assistant, whose name figured as selectee candidate under the scheduled caste category. In support of the caste status, the petitioner produced education certificate from Dr. C.V. Raman University, Chhattisgarh, where from the petitioner had graduated. It appears that in the process of verification of the genuineness and the confirmation of the certificate, the respondent board doubted the veracity thereof, since the same was furnished in Hindi and English language. It is stated that the correspondence is addressed to the said Dr. C.V. Raman University, seeking confirmation. First of the respondent came to conclusion that respondent came to conclusion that the petitioner had cheated the board for the purpose of gaining employment. Full stop. Therefore, the board lodged a criminal contempt before the police station concerned on 24/5/21 against the petitioner. The police has registered the crime number 86 of 21 in relation to the alleging offences and not in relation to alleging the offences under section 420, 465, 468, 471 of the Indian Penal Code. Full stop. The said criminal proceedings are pending it was stated that in the said criminal proceedings, the police initially filed C summary. However, the respondent board has filed the protest petition before the competent criminal court. Paragraph. The prayer in the writ petition was to set aside the memorandum dated 6/1/2022, whereby the appointment of the petitioner was cancelled on the ground of production of engineering certificate. The petitioner further prayed to confirm the appointment. Paragraph. When the criminal proceedings are pending in relation to the certification of the petitioner, which was the foundation of for securing the employment from the order of learner single judge in not giving relief to the petitioner at this stage and disposing of the writ petition by observations as above, including to dispose of the criminal case expeditiously, would hardly be halted. Full stop. No ground was paragraph made out to interfere with the judgment order or with the order of learner single judge. The appeal stands meritless. It is dismissed.
For appellant, my lord, kindly pass over the matter, my lords. Senior is held up in another court.
Passover may not be possible. We keep it on other day. What is it about? First August.
I appear for. Formally, my lords, there are the three IAs. One is for the dispensation of the sum of the annexures, which have been repeated between the one IA number 1 is for dispensation of some annexures which were repeated between the parties while we are filing the writ petition and the objection statement. Therefore, my lords, since they have already available, the one set of the copies we have produced it, I am seeking a dispensation of those orders as such is concerned, IA number 1. Well, that's the IA number 2.
Dispensation of annexures.
Annexures.
It is your choice. IA number 1. This interim application prays for dispensation of certain annexures. It is permitted. However, the official retain the annexures produced on record, which shall not be, although treated formally part of the record since they are withdrawn. Application is allowed accordingly. Yes.
Then, my lords, IA number 2 is filed under Order 41, Rule 27 of the CPC.
It is to be heard with main matter.
Main matter.
That is the law. What is third?
My lords, what I have sought is IA number 3 is regarding the stay of the matter. According to me, my lords.
For stay, we have to hear the main matter.
My lords, I shall go on. I shall go on with the main matter also. It may take little time, my lords. The 4 volumes are there. I can.
Whenever you want. Today you are not interested.
No, my lord, I'm interested. In the sense, I'm ready and I'm interested.
Then we proceed. Let us.
Please, my lords. But before I could take my lords to the order passed by the learned single judge, just I shall explain about 2 to 3 minutes what exactly is the position of the lands as such and the effect of the learned single judge's order. And but it's about when there were 4 suits were pending in the trial court in the year 2010. A revision petitions have been filed in the year 2012. And I have challenged the order passed by the Deputy Commissioner in a revision petition on the main ground that the matter was heard for my impleading application and for vacating stay before the learned Deputy Commissioner for that matter. And I can demonstrate it from the order sheet. But however, the Deputy Commissioner has proceeded to pass the order on the main matter. Therefore, my lord, my first submissions to my lord would be, it is against the rules of natural justice. May I pray my lords to kindly peruse page number 298 regarding the order sheets of the order sheet. Page number 302. May I pray my lords to kindly peruse page number 302. It can be visibly seen. Then I can point out, my lords, how the learned single judge has pointed out. He points out that the preliminary notification and the final notification have been issued on the same day, which is factually incorrect, and it was not even the case of the other side also. Number one. Number two, my lords, when the original suits have been pending, and we are agitating the matters before the court, at this juncture, the directions issued by the learned single judge to the effect that enter the name of so and so. Well, it is against section 135 of the Karnataka Land Revenue Act, the proviso to the same section. I can point out, since my lord is holding the learned single judge's order, may I pray my lords to kindly peruse page number 51. Fifth line. His Highness of Maharaja Mysore, under preliminary notification dated 24/6/38 and the final notification dated 24/6/38. If there is a final notification, I have produced an endorsement to the effect that there is no such final notification. Number one, the proceedings initiated have been dropped. Number two, under such circumstances, holding otherwise against the records. And my lord will further see if my lord would these are the lands situated outskirts of the Bangalore city. endorsement is the law of region.
So the acquisition proceedings are confirmed in one of the petitions. Which is that
Parallel.
petition?
Yes,
Which is that petition?
my lord, please come to 619, my lord. Volume 3.
Six one nine. At the instance of some other.
Some other person,
Some other.
some other person.
But that remains,
That-
that holds the field.
Pardon, my lord, that,
So in wake of that, how can you assert any right? In wake of this order,
Huh.
holding the field,
Huh.
not challenged, not reversed, not modified,
My-
not annulled, how can you assert
please,
any kind
please,
of
please,
right?
please. My lord may kindly peruse the page number 825.
Let us say this 619 first.
No, may,
619, page 619. Let us see.
oh, no, my lord, I am holding it. If my lord can kindly peruse, I shall read that one also. Immediately that may clinch the issue so far as,
This is same acquisition of 1941,
my lords, true. True, my lords,
as back in 1938.
true. I have produced that act also for the kind perusal of this honorable court. What exactly has been happened? I have produced an endorsement at page number 825. That will clinch the issue.
One second.
Initial stage, it will clinch the issue, my lords.
And the other petition 5271, which was by you, page 623,
Yes.
527 of 1995. Where certain findings were recorded. It is quoted by. Atha was changed in the name of petitioner.
Inam Abolition Act.
In
Under
respect
that
of
Inam
two
Abolition.
Well,
members
that-
and also certain demonstrate the petition.
That is under the Inam Abolition Act, wherein I am not a party, not connected with those two lands.
So this 5271 was also not challenged.
Well, 5271,
Was, neither this was challenged, this means
no,
30999 order was challenged, nor the order in 5.
my lord, so far as the 5271
Somebody
is
else, my
concerned.
lord, had filed claimed a tenancy rights. That, my lord, was also dismissed.
No,
Which
that exactly is, I shall point out, my lords, there exactly is the point. Otherwise, I would not have persuaded so much once my party has filed a FAR number 7, and if he has lost it, I would not have stand up before this court and arguing the matter. What has been happened is, one Srimati Rajamma, wife of Chikka Reddy, she has filed the FAR number 7
Under which law?
under the Land Reforms Act.
That is
Land Reforms
596.
Land Reform.
Page 5, yeah, Land Reforms Act. my lord.
Under the Land Reforms Act, my lords, claiming a tenancy right.
Claiming tenancy.
Tenancy right. My lords, so here how I am claiming my right is, I have purchased this property from Rajamma, wife of Krishna Reddy.
Then file a suit.
But my lords, therefore, the FAR number 7,
If it is independent of this acquisition part, then it is against
totally it is unconnected.
unconnected.
According to me, it is totally, so far as the land is concerned, it may be. But so far as the,
Yes.
totally it is unconnected for these proceedings. What happened is there were various other, my lords, I shall explain it in a nutshell like this. And if my lord could kindly peruse for a while, page number 825, that is an endorsement produced. May. wherein, my lord, the government has declared that I have dropped these proceedings. That's the, I am so much, page number 825.
Which is the third matter you were telling?
That is, my lord, page, my lord, 596 is a single judge's order where, my lord, the tenancy rights, my lord, were rejected.
Huh?
Confirmed, my lord, by the division bench at 610. 596, my lord, is the order of the single judge.
That is by the Rajamma.
Rajamma.
Rajamma, wife of Chikka Reddy. That exactly is the, why, how the things have been gone wrong, according to me, or according to the records I can point out is, Rajamma, wife of Chikka Reddy, has filed those writ petitions. The learned single judge also proceeds that I have filed a FAR number 7.
And para 4.
And I have lost the case.
604. Learned judge comes to the conclusion that, my lord, single judge in this, that there is a factory running, stone software. Stoneware pipes is running, all that converted. And that is confirmed in the division bench also.
This is confirmed.
Yes, my lord. Page 610 is, my lord, the division bench order.
That is regarding the land reforms matter, my lord. All the three.
Page?
610, 610, my lord.
But this, if it is confirmed, then these observations are also confirmed.
My lord, the question there, kindly see, that was the matter between Rajamma, wife of Chikka Reddy. Kindly see the two different persons. Wife of Chikka Reddy, she claims as a tenant of the property that FAR number 7 came to be rejected. Afterwards, the matter was confirmed by this honorable court. So what it communicates, according to me, is she is not the tenant of the premises. So far as myself is concerned, I have purchased this property in the year 2006 through the registered sale deed from Rajamma, wife of Krishna Reddy. If my lord can kindly when the acquisition proceedings have been dropped, there are two areas, my lords. 70 acres of the government land was there. 112 to 118 acres of the private land was there. So far as the 70 acres of the government land is concerned, absolutely we have no claim, nobody is claiming any right. So far as the acquisition proceedings are concerned, though they have been initiated in the year 1938, in the year 1941, by the government has come to the conclusion that the land acquisition proceedings have been lapsed. That is exactly my case. Government has said that proceedings have been dropped. It was the order as passed by the Chief Secretary then at page number 820. 825. If therefore, the theory of the acquisition, which has been put forward with reference to 112 acres is concerned, it has no legs to stand. No doubt the earlier order, this particular fact was not brought to the notice. And so far as my sale deeds are concerned, they have challenged it in the civil court. Both of us, we are agitating the matter there. When we are agitating the matter after 2 years in a revision petition, well, it's a provision to section 135, which is being known to this honorable court and everywhere it is there, my lords. Always the mutation entries are subjected to the original suit. When original suit is under trial, and with reference to the learned single judge order MR 4/76/77, which he follows, actually it is not connected. It is in no way.
We are concerned with all the serial numbers.
Well, I am concerned with only four survey numbers. I am concerned with 21 acres of the land. I'm not at all seeking any relief so far as the rest of the other things are concerned.
All serial numbers mean 10, 9, 7, 10, 7.
Yes, all of them are covered by this. And they had filed suits, withdrawn, appeal filed.
My lord, the suits are my suit. They have filed 4 suits and all the 4 suits are pending. They have filed the suit against me. Suit for declaration, they have filed it. And the suits have been filed in the year 2010. And still trial is going on. I have produced the original, plain copies of the original suits also. When and learned single judge proceeds mainly on the basis that Rajamma has filed for number 7 and she has lost her right. She is agitating this matter once again and we have purchased the property from the same Rajamma and we are agitating the matter. Absolutely, it is in no way connected. It is not only Rajamma, we have purchased it from 4 different persons, 4 different parties. Therefore, so far as if my lord could kindly peruse the learned single judge's order or the endorsement which we have produced at page number 825. And further, my lords, on page number 826,
Now this petition at page 596 arose from some tribunal's order. Which is that order? What was the case before the tribunal? Same.
Land tribunal under that
Same,
land reforms.
Tenancy rights.
Tenancy rights, same lands.
Same.
Lands are the
my lords, so far as that particular land is concerned, I am not the Rajamma, my lords. That's exactly my lord may kindly see. I am not the person so far as that particular writ petition is concerned. Neither myself nor my predecessor. How the learned judge proceeds is that exactly is my whole of my cases stands upon 2 points, my lords. Number 1, the Rajamma with whom I have purchased the property, I have purchased from 4 different persons. I have produced all the 4 respective sale dates. Number 1. Number 2, the Rajamma which learned judge refers to in his order is Rajamma wife of Chikka Reddy.
So you claim to have purchased from Rajam.
Rajamma wife of Krishna. 4 persons are there. Rajamma, Babu, Sarojamma. So they're totally 4 different persons, all the 4 different sales and different dates. All the 4 are for different dates.
in respect to the same land, that's all.
So, therefore, my lords,
acquisition of which is upheld.
So far as the land reforms is concerned, totally it is unconnected. So far as the land acquisition is concerned, my submissions to my lord is that the acquisition proceedings have been dropped by the government by virtue of the two endorsements which I have produced at page number 825 and 826. I'll put only two questions to myself. My lord may kindly peruse 825 and 826 and I'll try to persuade my argument, 825.
The acquisition order is there on record.
Please, my lord.
Order of acquiring the land.
Where is the final note? I'm only putting one question to myself. If they have produced the final notification, number one. Number two, because it is acquired for the company, part 7 is applicable. So they have to produce the agreement. In the absence of these two, final notification and the agreement, government in the year 1941 itself, the Chief Secretary of Maharaja has dropped the proceeding so far as the private lands are concerned.
Where is that?
That's what, my lords, I'm persuading. 825 may kindly be. 825.
508.
Page number 825 may kindly be seen. Volume 4.
508.
508, my lord, is
825 may.
825 also.
For my lords, it's my purpose. Volume 4, 825.
Why not 811?
But government order number so and so dated 37, then my lords dated 15/6/38. That exactly is the preliminary notification.
170. 172, my lord, I'm sorry.
One,
Note
825. Page number 825 makes.
172 is the order, I think.
I shall point out, sir. I shall point out. I shall read, my lord. Para 2. Government order number dated 22nd February 37, number dated so and so, dated 15/6/38. This is the preliminary notification. And 24/6/38 for the Mysore Stone Potteries Limited government order, direct the land acquisition proceedings failed. Kindly understand. Reasons: the in-time procedure not following, but the deputy commissioner, assistant commissioner, and the company's private land owners' payments records are not available. Final declaration was not issued by the government. So the land acquisition is rejected. That was the then, my lord. In the circumstances, the revenue commissioner's recommendation is sanctioned. This is dated 19/9/1941. Therefore, my submissions to my lord is, if there is a final notification, number one.
Is this page 825?
825, my lord, we don't even know what it is. But then, my lord,
no,
it is acquisition, my lord, is upheld by this honorable court.
Page number 826. 826.
Acquisition is upheld in which matter?
My lord,
That's what the order, what they are pointing out is order passed by my Lord Justice Chantan Gowda in that earlier writ petitions of land acquisition. He has said that you are asking for.
my lord.
He has asked
619.
609.
19.
Actually, this is acquisition is supposed to.
ಯಾರು ಹೇಳಿದ್ದಾರೆ?
609. Volume 3, na? Volume 3. 690. Oh, ನೋಡಿ.
It is declaring 2 acres and 15 foot. Total involvement.
Total, my lord, is there.
Total involved is 118 acres so far as this total acquisition is concerned.
What they had challenged, my lord, in that was only, my lord, in respect of that somebody like him came, Ramdas, and my lord challenged only that portion. Otherwise, my lord, the acquisition, my lord, entire acquisition, because your lords get that at page 178, the acquisition notifications.
My lord, this particular fact,
What? 178, my lord.
this particular fact of dropping the notification was not brought in the earlier proceedings at all. That's the reason, my lords, number one. Number two is Deputy Commissioner, my lord, my lord may kindly turn to the page number 302. The physically, my lords, it's, though both in English and Kannada, I have produced it. May I pray? May I pray for page number 302? It will be immediately touches the conscience of the court, my lord, for any reason, my lord. It touches the conscience of the court, not that it is only my case. Page number 302. Though it is in Kannada, my lords, I am not disturbing, my lord. Kindly see that gap. My lord, if my lord has got page number 302, kindly see the gap. How the Deputy Commissioner, while hearing the matter for interlocutory application, he passes an order on the main matter. When he specifically says he has heard, I have filed an impleading application and also application for vacating stay. That was being heard. It touches the conscience of the court according to my submissions, my lords. Page number 302. It is Kannada. I have produced the English, but Kannada immediately it is visible, not that words are required. May I pray? May I pray? Page number 302. And I can point out from the English translation also, 302 would be, because it is a Xerox copy obtained from the original order sheet of the Deputy Commissioner, wherein interpolation feasible. Interpolation is feasible. My lord got the 302. And on the right hand side, 12/10/2018, my lord, I don't know, my lord, whether my lord, I'm sorry if I'm taking the court's time, my lords.
No, you are entitled to.
No, my lord.
You have said nothing.
No, even if my lord has looked into what, I should not come in the way. I pray my lord's page number 302, just peruse.
Page?
302.
You are there? 302.
The Xerox copy first I have produced the translation. The Xerox copy, it reflects.
What is this? Roscom.
Page 302, my lord got that. 12/10/2018, it is the order set. I need not bother, my lord. My lord may kindly see the gap. That is the 3 lines on that 12/10. Ubhayat, both the parties are present. Adeshakkagi, means for the purpose of order. Actually, this was for interim order. Madhyantara Adeshakkagi. He has removed that thing. And then for final, even not Adeshakkagi, result. My lords, my first submission, that is my trump card in the originals, in the writ petition and in my pleadings, everywhere. This particular aspect, the learned single judge has not at all touched. This aspect, this is my, at least, I say that he can say it is inaccurate or I may be wrong. He doesn't touch in the, I have said so on not less than 5 places in the writ petition, and also in the writ appeal.
That is all.
Well, so that regarding the rules of natural justice, how it has been, I am basing upon this, number 1. Number 2, so far as the learned single judge's order is concerned, I may not repeat it, only I'll try to cover it up. Volume 1. Okay. My lord has already perused it. Para number 3, the total effect of para number 3, if I may say so with respect, that is the Karnataka Village Office Abolition Act, number 1. It is no way connected with the survey number or with the land as such. The petitioner is not a party to those proceedings. Number 2. Number 3, the writ petition was allowed and remanded, and that matter is pending before the, sorry, not pending. There is another one more important. The matter was remanded by this honorable court to the Assistant Commissioner. Once the matter has been remanded to the Assistant Commissioner, I fail to understand how the company petitioner, sorry, the present company, it files an application before the Tehsildar. Tehsildar initiates the proceedings under the KVO Act. Though I'm not a party to the proceeding, just I'm pointing out how the company is acting as such. It proceeds before the Tehsildar. Tehsildar was made as a party with reference to those Karnataka Village Office Abolition Act. Under the Village Office Abolition Act, Assistant Commissioner and the Deputy Commissioner are only the authorities, and he passes an order. Though it is not, I need not challenge, I am not a party, but that is how the learned judge proceeds so far as para number 3 is concerned. Then, my lords, in para number, page number 53, exactly I will only repeat it in 2 sentences and I may not trouble it. Page number 53 of the learned single, where learned single judge's order is there. May I read? Accordingly, the application was dismissed. Similarly, the attention of this court was drawn to the annexure R12, which is an order passed by the Land Tribunal, Bangalore North Taluk, on a petition filed by Srimati Rajama and others, who are respondent number 7. Kindly see.
You are referring for all the private respondents? Yes.
Well, if I can prepare a table and submit it, if I can prepare a table how exactly the learned single judge order. Coming to this.
Prepare, when will you prepare?
Well, maybe next week.
No, not.
I can make it. My lord, it is not that I'm keeping away from the courts. No, whatever may be the orders, my lord, it's my duty to assist, nothing beyond.
Can prepare table by Monday.
Pardon?
Monday.
Monday, I'm not there.
Tuesday.
Tuesday, fine. Tuesday, fine. Tuesday, fine.
Prepare the table. Tuesday at 2:30,
Very well, once.
so that it is, we remember.
Others, I should not come in the way of the list also. That's, I understand my difficulty, of court's difficulty, my lord.
No, you are not coming in way of this.
No, my lord, the courts, ultimately, thousands of cases are there, but at the same time, the citizen also feels that, my lord, it's not that the advocate. Really, if that particular 2 things have been held against me, absolutely, I may not stand here.
We'll take up at 2:30
Very well.
on Tuesday.
Number 23. So Nagaraj, yes, party in person.
It is part in person.
My lord, I am the appellant. My lord, for 23.
Yes.
My lord, I am the appellant. My land survey number 184 Tumpur has been subjected to acquisition by National Highways in the year 2000. Till date, they have not taken and they have put into use as a single bit of land of 9 guntas, measuring 9 guntas. Even till date, they have not taken the possession. They have forcefully paid certain amount in installment.
For the first time. So he appears to be wanting additional compensation for 9 guntas,
Yes, my lord.
which the highway authority is acquired.
Subjected to acquisition.
It is acquired or not acquired?
It is not acquired.
Then how can you claim compensation?
It is, they have paid certain amount forcefully, arbitrarily. Their certain portion damages is even not paid.
9 guntas are not acquired. How can you?
It is, they are putting it to use. They are using it already.
Using it.
Yes, my lord. From 2000.
Compensation in respect of 1 gunta of land. My lord, he has received compensation in respect of all the 9 guntas.
They have not followed the statute. Certain portion has not even been paid. That has been recorded by this learned single judge. They have not followed the statute.
Paragraph 37 is here.
Paragraph?
37, page 58.
That is about 6 guntas. So how come that 9 guntas come into this?
My lord, there's a bit confusion in a lot. He's claiming compensation again in respect of 1 gunta.
My lord.
That single judge has called out from paragraph 37, explained. Taking note of all the earlier proceedings.
They have not followed the statute. It is in violation, gross violation of Article 300. Certain portion, even they have not paid. They have made me to, they have paid in installments spread over 15 years, and they have not paid the damages as of now. I need relief, my lord.
Forty-three is very clear, not 43 and 44 of the order of the judge, page C1.
Paragraph 40. It refers to the award and the last 5 lines in this award, apart from determining the compensation at the rate of rupees 250 for 1 gunta of land, a sum of rupees 68,470 was awarded for use of occupation of the land before acquisition. Though that will include 9 acres. Possible. Yes.
Madam, my lord, para number 22 of the judgment. Though it has been used from 2000, they have paid from only considered from 2006 to 2013. Earlier, they have not paid. Like that, there are all, and they have not followed the statute. None of the procedures does not, there are no such provisions or sub-provisions available in the law. They have made two preliminary notification was made in the year 2000 for 9 guntas, 6 guntas they have made, and 2 awards made. One was made within the time after lapse of 5 years, then they were made one more award in the same proceeding. none of the procedures adopted does not, there is no such provisions under the law. It is a gross violation of the, under Article 300. And even they not paid. Really, they have made me to run before the court for almost 24 years.
Story heard, learned party in person, Mr. S. Nagaraja. Petitioner party in person.
My lord, there is one more citation is there. Citations. One more. In a recent Supreme Court judgment, if they have not followed the statute, there should be it should be provision or a sub-provision. Otherwise, it is unconstitutional and it is invalid. It is very recent. A preliminary notification was issued in the year 2000 to an extent of 9 guntas. They put into use as a single bit of land in the year 2000 itself. Then next, a final notification was made for 6 guntas, not 9 guntas. They have put it, the entire 9 gunta as a single bit of land. Finally, they have made for 6 guntas. A first award was made in the year 2003 for 2 guntas only. And after lapse of 4 years, then one more award has been made to an extent of 4 guntas. Two split ಮಾಡ್ತಾರೆ. There is no such provisions under the Act, National Level Act. And also there is a decision while they're making this thing. Page number, they wanted to, volume number 2. Volume number 2, page number 385. 384. They have paid, they have awarded for 2 guntas and a decision was taken to denotify the balance 4 guntas. Typed by this thing 184 is so 387, page number 3, volume number 2, 387. Survey number 184, last in the end. To give statement on Kadedar's page number 391. Page number 391, volume 2. Page, volume number 2, page number 391. Survey number 184, converted 2,490. As per the RTC, the land bearing survey number 184 in the name of S. Nagaraja and S. Hemelda jointly. The entire survey number is converted to residential purpose, out of which only 6 gunta is acquired, but the survey number sites were formed only for sites who measuring 2,494 has been considered for compensation. The balance area proposed to take action for denotification. Later, after 4 years, they cancelled the denotification and they have paid the amount. 2 awards has been made for a single final award, final notification, final notification. That does not, there is no such provision. There should be a provision under the Act to do such, split awards or sub provision should be there. There is no such. The recent Supreme Court judgment says,
Judgment and order dated 9th May 20.
and they will- in the they have put into use 9 guntas. Then they made purchased 2 guntas additional. That also does not have any law is been there. Then additional 1 gunta they made it in 2000. They put into use up to 2013. They have made one more preliminary notification, superseding the one which is already existing. Then they have paid only certain portion, only up to 2006 to 2008 payment used for that they have paid. Then earlier 2001 to 2006 they have not paid. Like this, they have made me and to run before the court for almost 1350 as of now. They have not paid the damages as of now. There is a provision under the act, if at all, if they, because I cannot use, they are put into use. I cannot sell, I cannot use. I have been lost the earnings of that. I need damages or some relief I need. Yes, my lord, that's all.
So for orders tomorrow. Tomorrow for orders.
My lord,
For tomorrow for orders.
day after tomorrow, I have to go appear before the other court,
Other court, which court?
trial court.
High Court, Supreme Court.
No, Supreme Court, I already gone to the Supreme Court. Supreme Court has to, directed me to approach the jurisdictional high court for relief under article. There is a judgment is also there.
Which High Court you?
Supreme, this one early, tomorrow's is trial court, some other order. Supreme Court has directed this case referred to High Court for relief under Article 226. Clearly written. It is, I can, volume number 2.
All at Monday.
My lord, yes, I will call you.
Monday? Monday.
Monday,
some other court you are going?
no, I have 29th, no, yes, my lord.
29. On that day, you're not going to any court?
No.
29.
Because I am being engaged by the government to address the pre-independence case
Correct.
that has come to final stage,
29.
But 24, should be next day?
Lord, petitioners herein, my lord, were the owners of the land, my lord, measuring 1 acre 36 guntas in survey number 58/2. Lord, the admitted position is that, my lord, though final notification has been issued in 2010, as on today, my lord, award has not been passed, possession has not been taken. Lord, as submitted, my lord, the preliminary notification was issued on 21/5/2008.
Yeah.
21/5/2008. Final notification, my lord, on 18/2/2010. Then, my lord, since the award was not passed, I filed a writ petition before this honorable court, before the learned single judge. My lord, for a direction, my lord, to pass up award. My lord, that, my lord, is filed in WP number 34161 of 2013, annexure page 83, my lord. Page 83, if you lost, may kindly turn to page 83. The single judge disposed of the matter, my lord, with a direction to the BDA to pass award within 8 weeks. My lord, this order, my lord, was passed on 30th September 2013, page 83. Though a direction was issued, my lord, as on today, award was not passed, possession has not been taken. That can be, my lord, seen. Your lordship may kindly turn to page 174, my lord, the endorsement issued by the BDA.
So where is that? This is the challenge to the, where is your petition and the order?
My
Where you
lord-
challenge the, where you seek the direction to pass the award?
Yes, my lord, page 83, my lord,
83.
page 83. So my only contention before the learned single judge was that the award had to be passed within a reasonable period of time. Since that has not been done, the BDI, my lord, has abandoned the entire acquisition, therefore acquisition has to be set aside.
Now this 2013 Act provision will come into play.
No, my lord, for the BDA Act, my lord, the honorable courts have held that the 2013 Act is not applicable.
Notice returnable.
My lord, may I seek, my lord, let them not take possession of the property, my lord. Admittedly, I am in possession. As for their endorsement itself.
Notice returnable on 13th August. In the facts of the case, since the petitioner, since the appellant asserts that he is in possession of the land, both the sides are directed to maintain status quo
Okay.
with regard to the subject matter land till the next date.
Number 25, Tamrish BN.
My lords, appearing for the appellant, my lords. My lords, I had appeared for the CET exams, my lords, for the year 23, 24 and 25, my lords. And I've attended all the questions, my lords, but however, a controversy rose, my lords, stating that some of the questions which were asked by the board, respondent number 1, route 2, they were out of the syllabus. And hence a committee was formed, my lords, of 3 members. And out of the 3 committees, my lords, they found that in PC, for physics, out of 60 questions, 9 questions were out of the syllabus and they were deleted, my lords. There were 9 questions. And in chemistry, 60 questions, out of 60 questions, 15 questions were out of syllabus. And in maths, 60 questions, out of 15 questions were out of the syllabus, my lords. The committee was formed, my lords, and gave an opinion. These were the questions which were out of the syllabus, my lords. Without any status or anything, my lords, the government has deleted that question and has stated an order has been passed, my lord, stating that these questions are to be excluded and marks not to be calculated, my lords. I have appeared for the physics, chemistry, maths, and out of 39 questions, my lords, out of these 3 subjects, I have attended 20. And each marks in the CET exams are very important, my lords. So they have excluded my 20 marks out of 39 questions, my lords. And hence, I've been aggrieved by that order, my lords, press note. My lords, I've secured 7,640 ranking, my lords, from the questions which I have answered, my lords, out of the exclusion, my lords. Being aggrieved by that, I have approached the Honorable Court, my lords. The Honorable Learned Single Judge found out that the questions were out of syllabus and stated that my grievances were true, my lords. But however, did not proceed further to set aside the order and grant me the relief which I had sought for, my lords. My lords, para number 6, my lords, page number 25 of the judgment, my lords. My only prayer is, my lords, to include my answering and grant me the marks, my lords, and recalculate my ranking, my lords.
This is relating to SCET examination.
Please, my lord, CET exams, my lords. My lords, I attended all the 20 out of 39 questions which were deleted, my lords. My lords, in page number 97, I was granted with the D3 paper, my lords. And in that paper, my lords, out of 10 questions, first 8 questions were out of the syllabus, my lords. I've attended because as a prudent student, out of 10 questions, 8 were asked, my lords. So I've attended all those questions, my lords. But without considering what would be the future of the other students, my lord.
Outside syllabus question.
That the learned single judge has considered, my lord, paragraph 6, last last two sentences in page 26.
Yes.
My lord, may I read, my lord? Needless to state that such mistakes ought not to occur in future. The KA and the state are required to take adequate measures to avoid such situations in future. My lord, the next paragraph, it is the contention of the state that individual grievances may not have the effect of unsettling the entirety of the person, which stand of the state also requires acceptance.
My lords, the country,
And committee was constituted,
My
which
lords.
counted the 50 questions.
my
of
lords,
opposition.
out of 60 questions, 1/4 were not out of the syllabus and I have attended, my lords. As a student, I would be not knowing whether they will give me, whether these questions will be expunged or not, my lords. As a student, I would have attended all the questions which were in the marks in the paper, my lords. My lords. My lords, I'm relying on the judgment about the individual grievances, my lords, but my rights were violated, my lords. Even if one person's rights are violated, the court has to interfere, my lords. I have attended all the questions and I have secured 7,604 ranking, my lords, without considering that deleted questions also, my lords. I have attended 7,604, and each marks, my lords, will be affecting my college, allotment of college, my lords. Each marks, my lords. And 1/4 of maths paper, 1/4 of chemistry paper, my lords, they have asked out of syllabus. I would not be knowing, my lords, as a student, I would have attended if I know the answers. I would not be knowing in the future, the government may come and say that these were the questions which were out of the syllabus, they would expunge. So I have spent around, for each question, they have given me 60 minutes, my lords. So as a prudent, I would have attended all the questions, my lords, not knowing the state would come up in the future, my lords. My lords, I'm relying on the judgment, my lords. My lords, the first judgment, my lords, Avani Prakash versus National Testing Agency and others, my lords. 2023 to SSC 286, my lords. At para number 60, my lords.
Number?
60, my lords. Of page number 35, my lords. My lords, may I please, my lords? In our view, the first respondent cannot be allowed to simply get away when confronted with the situation in hand whereby injustice has been caused to a student by standing behind the situation of a large competitive examination. Individual injustice originating in a wrongful denial of right and entitlement prescribed under the law cannot be sent into oblivion on the ground that these are a necessary consequences of a competitive examination, my lords. My lords, I would have, if that marks were considered, my lords, I would have got in a good college, my lords. Because of the blunder committed by the state government, my lords, asking the question out of syllabus and me answering whether they would be taken or not, my lords. Now my ranking is affected, my lords. If it is 1 or 2 questions, it's fine, my lords. But 1/4 of the questions were out of the syllabus, my lords. 1/4 of the questions were out of syllabus, my lords. And the next judgment, my lords, about the review, my lords, judicial interference, my lords, at page number, para number 16, my lords. The second judgment, my lords. Page number 46, my lords. From the 4th line, my lords, 5th line, my lord. The scope of judicial review when examining the policy of the government is to check whether it violates the fundamental rights of the citizen or is opposed to the provisions of constitution or opposed to any statutory provisions or manifestly arbitrary, my lord. Here, the members which were formed, my lords, have stated that only these questions were out of the syllabus. They have not given any opinion, my lords. But the state government, without referring on what provisions they are acting and without considering the future of the students who might have answered it, just bluntly have deleted the question saying that we will exclude the marks and will not consider it, my lords, without considering the future of other students, without the considering future of the students who might have answered. There might be some alternative mechanism, my lords, marks or grace marks for the students which have been asked, my lords. I've attended 20. Regarding my lord, at least my paper may be reevaluated and considered, my lords.
That is all. Dismissed.
My lord, with your lordships kindly,
May I make one submission, my lord?
Mr. Phanendra. There is a request to assist us
Please,
in the dengue matter.
very well.
Suo motu. So they have filed some replies, but we'll ask them you to serve a copy of the entire set. And we'll post it to a date convenient to all of you.
Any, let them serve, my lord, sir. I'll look at it.
Tuesday,
Please, my lord,
next
Tuesday.
Tuesday.
Very well. Fine.
Kind permission, my lord.
Yes, Mr.
Vikram Nakul is there.
85. Rate petition 10-835/2020. Where is that? Where is that last name? Student one. Dismiss. One. 10. Governor Advocate Mr. Mohammed Tahir seeks permission to withdraw the present writ petition. In this regard, he files memo dated memo today, which is taken on record. What is this with the we to challenge the, what is this? Challenge the question of law.
Question of law is involved, my lord. In other petitions, my lord, when needs arise.
Full stop. It doesn't need.
Please.
It is dismissed as withdrawn without expressing any opinion on the merits of it.
My lord, serial number 83 also, your lordship, wherein I have filed an application for memo for withdrawal.
You are withdrawing.
Yes, your lordship.
Same order.
Grateful, my lord.
Learned Advocate Ms. Leela P. seeks permission.
Grateful.
Serial number 91, my lord.
Memo is submitted. All right, same.
Serial number 91, my lord, it's a PIL.
My lord, the learned advocate general will be coming, my lord.
I appear for the.
The senior counsel also present online, my lord.
Yes, will.
Your party in person. 91.
Party in person, senior counsel is appearing.
Your party in person.
I am the petitioner in this case, my lord.
You can't appear.
The senior counsel is online.
Then you don't address the court, please. Not permitted to address the court.
The counsel on record is present.
Not permitted to address the court, please, unless the certificate is given.
My lord,
This is not the party.
My lord.
My lord's permission, my lord. Serial number 91, I am the counsel on record.
Yes, yes.
Serial number 91, my lords, I am on
What is to be done?
My lord, this is with
the senior
regard to
counsel appearing through.
Let him appear. What do you want? Yes.
my lord, this pertains to the landslide matter, my lord, which was there yesterday, moved on and
Yes.
at 2:30, the learned advocate general will be appearing. My lord may just have passed over, my lord, because
It is
instructions
listed.
are being awaited.
It is listed today.
Yes, at serial number 91.
Lord, it is posted for their status report. Let the status report come.
Yes, it has come or not? Where is that matter?
My lord, the state's status report will be submitted.
So far as Union of India status report is this, what we have done.
Is that on?
The report which is referred to in the order is by the state.
No, my lord, it's by the union government, government of India.
But we have our report.
Now, respondent two shall also file status report and also future course of it.
My lord, we'll have to file, my lord. The learned advocate general is.
Will not let them file, will not let them file the report and serve a copy on us.
Any casualties happened in that lens?
Yes, my lord, sir, there are about 8.
8.
Lord, I have a status report, my lord. What happened in the last 24 hours, my lord, I have a status report. May I file this, my lord?
Para number 10.
In furtherance of order dated 23/7/24, Governor Additional Solicitor General Mr. Kamath files
Sir, give us a copy, sir.
another report delineating the events and the measures taken by the authorities in relation to the situation obtained post landslide.
Yes.
They said,
Rescue operations. The rescue operations.
which includes the details of the rescue operations. The said report is taken on record. Paragraph. Learned additional government advocate, Ms. Nilofer Akbar. What do you want? Time.
My lord, the report is ready. If my lord could just pass it over, I'll
Pass
get
it
in.
over. Pass it.
I'm sorry, my lord, I apologize.
Shall we pass it over or what, Mr. Counsel? You are muted, you.
Your lordship may have it on another day, my lord. We will go through the report also.
Full stop. While learned paragraph, while learned additional government advocate Ms. Nilofer Akbar stated that the state shall also file report in course of the day.
My lord, tomorrow I'll file it by tomorrow.
Shall also file report in the course of.
I'm sorry, the learned advocate general is on his way. He's coming, my lord.
But they are seeking time.
Very well.
Also file report in course of the day from a learned senior counsel, Mr. So-and-so, so-and-so. What is your good name?
V. Chidambarish.
Yes.
Chidambaram.
Chidambarish.
Yes.
Appearing online submits that he would like to go through the further report which is filed by the central government today. He requested to grant time, full stop. The petition shall be next listed on which date? First of October.
Yes.
First of August?
Yes, my lords. Obliged.
First of August, as requested.
Obliged, my lord.
As requested by the council.
My lord, serial number 51.
Before the next date, office of objection shall be removed.
My lord, serial number 51. I request to withdraw.
Serial number?
51, my lord.
51.
Okay, you can reply.
51.
Petitioner.
Read petition 14154 of 24. Learned advocate Mr. Ravindra Gajan. You are Ravindra Gajan?
Date is there.
My lord.
Ravindra, you are Ravindra Gajan.
I'm
That is what
colleague,
you
my
are.
lord.
Date and to put here.
I'm his junior.
What is your name?
Have a copy of-
So
I'm Rajesh,
so
but my
appearing for
his colleague.
learned advocate
It's
Mr.
being taken up.
Rajesh Bhatt.
Please, my lord.
This,
Tenders memo dated 24/7/24.
you filed it. Yeah, where am I?
Reads the agenda.
Yeah. Take this. Yeah, you did.
49.
I'll serve it on him. This is the copy given by them. Today's. Yeah,
Petition is dismissed as withdrawn and
given by the.
permission sought to withdraw the petition. Is observed that any further development which may be adverse to the petitioner shall give fresh cause of action to the petitioner. Disposed of accordingly.
Serial number 9 matter. Serial number 9.
Serial number 9.
9.
What do you want?
It's for issuance of the notice, my lord.
Pardon?
It's an order of this court is not complied by the accused in this matter, my lord.
It is passed over. Why you are
It's-
mentioning?
Sorry.
This is not the way to mention.
Sorry, my lord.
Since how long you are practicing?
1 year, 1.5 year. 1.5 year, my lord.
1.5 years. Let it be called out. This is not the way to
my-
interject the proceedings.
Sorry.
Call out that matter.
May I lodge? Party in person in 78 CL number. Notices have been served, my lord. And the learned government pleader here wants some more time for counter. So that can be granted and a short date.
Party in person, Mr. Murali.
Yes, my lord.
What do you want?
My lord, the notices have been served. The learned government pleader here wants some time for counter. So if you can give a short date by in 2 weeks
No
time.
government leader has requested us for any time. Yes. 78. Nobody has requested so far. Yes. Lord. Yes.
The passover matters, list one, serial number 9, Mr. Vasant Kumar HT.
Client in this matter, my lord.
Notice returnable on 7th August.
Wait.
Today when the petition came up for consideration, today when the present suo motu petition came up for consideration, the court figured on record the replies filed by the state government. Full stop. The court thought it fit to request learned senior advocate Mr. Phanindra to assist the court in the cause by playing a role of amicus curiae. Full stop. He has gracefully agreed. Full stop. At his request, stand over to 31st July 2024. Don't write gracefully. He has agreed. He has agreed. Assist the court. Thirty-first, is Wednesday. When shall we keep this dengue matter?
Dengue matter, my lord, my colleague is appearing.
31st or 30th, when it is kept?
Lord, we have filed our status.
No, when it is kept? 30 or 31st? When is to be kept?
31st July.
31st. Inform Mr. Anand.
Yes.
Serial number 17.
Let us appear for the appearance matters. It's the morning, my lords has asked a question regarding whether we had raised the issue of maintainability before the learned single judge.
We have not asked anything.
So, sorry, lords.
Yes. These amounts were paid by whom?
My lords,
The amount is paid by whom?
deposit before the honorable court, my lords. The amount deposited by the court, my lords. It's the deposit by us, my lords.
Paid by you
Yes, my lords.
towards gold.
Now, my lords, the gold, they defaulted the loan amount, which is subject matter of 17 and 17.2. We auctioned it. The Learned Single Judge directed us to deposit the amount before the registry of this honorable court. To that extent, it has been deposited. That is the amount realized by auctioning the gold in lieu of the default, my lords.
Now, the petition cannot lie at your instance. They are the private company.
My lord, regarding that one, there was argument, my lord. Private, it is established, they are getting license to run the money lending, my lord. It is for a public function, they are discharging a.
It is not a public.
And also, they are established under the state, my lord. It comes under Article 12 also, because it is my livelihood for which I had taken the money, my
You
lord.
are a company incorporated and the Companies Act.
Companies Act, my lords. Private institution, my lords.
They are established
My
under
lords,
the state.
may I make one humble suggestion, my lords? There is an arbitration clause in this matter. The matter may be referred to an arbitrator by this petition itself, my lord. In fact, it can be done if both the parties are consented. So that, my lord, assuming that the
Arbitration clause in what?
in the agreement itself.
Agreement.
Yes, my lord, it is there. Assuming that, my lord, they got a genuine case, my lord, let the arbitrator adjudicate the matter, my lord, instead of relegating the respondent herein for filing another case, my lord. That secures justice for both the parties. My humble
Right.
suggestion.
My lord, during filing this one, my lord, the Debt Recovery Tribunal was not functional, my lord. Second thing is a national policy announced by the government of India regarding COVID pandemic, my lord. And in such extraordinary circumstances, the Honorable Court exercises power, my lord, inherent powers, my lord. It was COVID pandemic, my lord, and it's a national policy. It is binding on them, my lord, even though he's a private financer. And not only that, my lord, when there was a stay, he has actioned the gold and melted the gold mine. And the action is for 24 lakhs, when the amount itself is 41 lakhs, my lord.
What is the amount lying deposited in the register?
My lord, it's 24 lakhs
39,000.
24 lakhs
39,085 rupees.
85.
Rupees.
24 lakhs 35,000.
39,085.
It was deposited in February 2023, my lord.
So we'll permit you to avail the remedy of either civil remedy or arbitration, whatever.
Yes, my lord.
My lord, I may be permitted to release that amount, my lord. I am in financial crisis because they have sold my gold. They have actioned my gold, my lord. I was supposed to get my jewelry back. Even after actioning, they give only 50% loan, my lord, against the property. They take 100% security. If that is so, I had deposited 618 grams of gold. Even today, when the rate is counted with the market value, it will be 41 lakhs, my lord. Therefore, the Honorable Court called for the records. What was the auctioned amount, my lord? And there was a direction to deposit the market value on 12/11/2022, my lord. But they deposited the auctioned amount.
Lord learned advocate, this is serial number 17.
17. All are impugned, 17, 17.1 and 17.2.
ANISH, Jose Anthony for the appellant company. And learned party in person as respondent Dr. S. Shobha, at length. The present writ appeal. At the instance of the appellate company, arises out of judgment and order passed in common in 2 writ petitions.
3 minutes.
Three writ petitions dated, there's been an order dated 28 February 24 in three writ petitions. Photo sprayed in the petitions by the petitioner plus respondent party in person hearing was to require and direct, was to direct and require the respondent company to waive the penalty interest and compound interest demanded by the respondent Muthoot Finance and to reduce the interest rate of 26.87% from 26.87% as demanded to 1.17% for the gold loan. Of rupees 15,00,100 for the period from 20th/3/21 till 7/10/2020. The other two petitions contain the similar prayer. The grievance of the petitioner was in respect of the notice received by the petitioner from the respondent as appellant herein, Muthoot Finance Limited, seeking to recover the unpaid loan amount. It appears that the petitioner had availed, paragraph, it appears that the petitioner had availed 3 gold loans from the appellant company. While the one loan was for rupees 15,00,100, the other two loans were for rupees 4,65,000 and rupees 4,05,000, in respect of which the amounts of rupees 19,52,775, 6,00,032 and rupees 4,18,081 respectively were due. The borrower plus petitioner defaulted, paragraph, in repayment. Therefore, the company issued notices to auction the gold. Full stop. This gave cause of action to the petitioner to file the petitions against the company. It appears, paragraph, that interim orders were passed while on a single judge. Requiring. It appears that in the meantime, the auction had taken place.
No, my lord, action was not taken.
Not why the amount was
I had
directed.
issued auction notice, my lord, and it was a COVID pandemic. And stay was granted. After the stay, they actioned the gold, my lord.
It appears that interim order was passed in the petitions, which
On
was,
9/2/22, the interim
were-
order was passed.
which were breached by the company, therefore.
No, my lords, there is not breach, my lords.
Huh?
It is not fulfilled, therefore.
Why you were we required to pay the amount, deposit the amount?
My lords, the interim order was violated
Ah,
by the respondent,
Ah.
therefore we auctioned. It was a misconception of fact that there is a violation of interim order. But even today,
but it was auction.
it was auctioned, 36/2020.
In the meantime, that only right there. In the meantime, the auction took place and the amount of 24,39,085 was realized
Yes,
from the auction. Full stop. Finally, the writ petition for the reasons recorded by a single judge culminated into the following operative order, extracting the relevant part, and only this one, 2 and 3, page 32.
My lord, they had not even intimated the court, my lord, when there was a stay, they have actioned the gold, my lord. They have not even filed an application to vacate the stay, my lord. Therefore, the court came to the conclusion there is a verge of contempt. In
While
the
we
teeth
can,
of contempt, they have done
while
this.
the court examining the appeal, considered the controversy raised in the petition, from a conspicuous aspect surfaced that the petition was filed against the company named Muthoot Finance Limited. Admittedly, the respondent company is a company registered under the Companies Act 1956 or 2013.
56 minutes.
1956. Full stop. It does not answer the definition of state, inverted comma, within the meaning of Article 12 of the Constitution, nor the transaction between the petitioner and the respondent could be said to be involving any public function or could be said to be in public realm. Also, the company is not discharging any function which has the trappings of sovereign function. Also, respondent company is a private company registered under the law. It is not a state. Paragraph. Once the above position is clear, comma, the writ petition would not lie against the respondent company.
My lord, loan are dispersed
On
under
a single
statutory
judge.
provisions, my lord.
Learn a
Loans are
single
dispersed
judge.
under statutory
Learned
provisions, my
single
lord.
judge. Learned single judge could not have, therefore, entertained the petition on that ground alone. Paragraph. Noticeably, learned single judge was aware about the said aspect that the petitioner, that the respondent company did not have the status of a state under Article 12 of the Constitution. Full stop. What was reasoned by learned single judge to entertain the petition, notwithstanding the aforesaid aspect.
My lord,
Was-
DRT was not functional, my lord, that time. DRT was not functional, my lord. Deputy
Was-
Recovery Tribunal was not functional, therefore we came before the High Court, my lord. And that too, it's a national policy announced for COVID. They are binding on that. COVID pandemic, they are binding on that, my lord. Anybody in India is an Indian citizen. He has to bind by the national policy, my lord. When there is a COVID, that is why I've been a regular payer since 6 years, my lord. I've paid the EMIs regularly. Not even once I have defaulted. Mainly because it was a COVID. I was not able to, my lord. They only said there is a moratorium period of 6 months. It's been recorded, my lord, you can see at CCTV itself.
Yeah, Lika, what did I? Was that since the financier had acted contrary to some interim order, the petition merited entertainment. Full stop. The court does not endorse to the said view to make the petition maintainable on the said count. Full stop. Following was observed by law in a single paragraph. Then on page 29, since on this fact, the financier had acted contrary to Paase Karke deposited before the court. Paragraph. Thus, it is clear that though learned single judge was well aware that the respondent company did not come within the purview of the state or its instrumentality under Article 12, he proceeded to entertain the petition and pass the order. First of the party in person submitted that it was a COVID time when she approached the High Court by way of petition. Therefore, it ought to have been entertained. Most of the court is not impressed with the submission. Paragraph. The remedy for the petitioner is to institute the civil suit and to seek appropriate relief. It was further pointed out by learned advocate for the appellant that the loan agreement between the company and the petitioner contains an arbitration clause.
Yes.
Full stop. The loan agreement figures on record into bracket page 88 onwards, which is found to be containing such agreement. And where is that agreement?
My lord, it's page number 56, my lord, it's para 6.
Which the arbitration agreement is found in paragraph 6 of the loan agreement. Paragraph. So option 2439,085 realized. Why you add there? The said amount is deposited with the registry and is lying with the registry. Paragraph. In the aforesaid view, when the petition itself was not, and the petition itself could not have been maintained, this court is inclined to allow the appeal. Also, the order of law on a single judge impugned in the appeal is accordingly set aside. Paragraph. Following order shall govern the rights of the parties. 1. It will be open for the respondent original petitioner to institute.
Parties, maybe parties. Both the parties members.
Why you should institute this?
Any claim is there, my right should not be curtailed, that's all. Any claim is there, my right should not be curtailed, that's all.
Please don't give even a single pipe. Even the gold also, you keep it with you. I'm just, I'll file an affidavit before the court. When there is no justice here, please don't talk now. When there is no justice, I'll file an affidavit, my lord. Let him not give anything. When he has actioned the gold, when there was a stay here, he is talking about so many things now. The court had appointed a court commissioner and for settlement also. He did not agree that time. Not only criminal case is lying on him, it's contempt also is lying on him. Please refer the matter to contempt bench and criminal bench also.
First, it will be open for respondent petitioner to have recourse to civil remedy
Yes, my lord.
before the appropriate court in relation to the claim and grievance which she agitated by filing the writ petition. Full stop. The appellant company is also not precluded from taking any recourse of law if it is of the view that it has claim against the petitioner. 3. The amount of rupees 24,39,85 which has been realized pursuant to auction conducted by the appellant company shall remain deposited with the registry of this court. Next, the registry shall invest the said amount in a fixed deposit with a nationalized bank, initially for a period of इससे पहले, is before that. It is also for the, it is also open to the, is also open to either side to invoke the arbitration clause and engage into the process of arbitration in relation to the disputes. Next, then the amount deposited. Then it's been invested in with a nationalized bank, initially for a period of 1 year and renewable. The amount of interest which may accrue on such amount shall be receivable by respondent petitioner. Full stop. With the efforts, the appeal is accordingly, the appeal is disposed of as above.
It's only one submission, my lords. After 1 year, the principal amount may be ordered to release to me since
Renewable. The fixed deposit shall endure, shall continue to endure till the outcome of the dispute between the parties.
there is no cases, they are not raised any claim, my lords, again within a reasonable time, my lords. This grateful, my lords.
Renewable and renewable for maximum period of 3 years. The parties shall, it will be open for the either parties to take the aforesaid recourse of civil remedy and oblique or arbitration within a period of 3 months from today.
Grateful, my lords. Grateful.
Thank you, ma'am. I've come to the temple of justice, ma'am.
My lords, the same order shall follow.
All the 3 appeals are accordingly disposed.
Grateful.
That's the 230 matter, seal number 84 to Vijay Kumar for withdrawal. Withdraw. The 84 to Vijay Kumar Bagoji.
Withdraw. Figures on the record. Memo for withdrawal dated 2/7/24 filed by learned the appellant, Mr. Vijay Kumar Bagoji. Paragraph. The memo reads as under. Quote the memo. In view of not in view of memo, the writ appeal is dismissed as withdrawn. It is observed that any future development will give rise to press cause of action. And the remedy at that time shall be open to the appellant only in accordance with
Number 86. Sachin BS.
86, my lord. It is a parted matter. Mr. Ashok Karnali is to reply. The petitioner had finished and Ashok Karnali. So may I request for a, sorry.
That commercial market.
Yes, my lord. Vegetable market. My lord, may I request for a short passover or short accommodation? Mr. Ashok Karnali is to reply.
Lord, I think a solution can be found. Lord, what I have gathered is that on behalf of the Archaeological Survey of India, the first 100 meters is the protected area, and the next 100 meters is the regulated area. So the alleged construction is after the 100 meters, so it is in the regulated area, which means a construction can be made, provided that the the Monument Authority, National Monument Authority has to give a NOC. Now, on behalf of the National Monument Authority,
To give a note.
as to give no objection.
No.
Now, we have not given a no objection by following a policy that no NOC will be given where the construction has already commenced. Now, Lord, this has led to a gridlock. So, Lord, what I thought was, I will get instructions. Lord, if your lordships can direct the National Monument Authority to consider the grant of NOC as though there is no construction, but with whatever conditions that we can stipulate. Lord, I thought that would help resolve the issue.
Only thing we had a mind passing thought in that line last occasion. Only thing that it will be amounting to require you to act contrary to your policy.
I'm sorry.
Court would be directing you to act contrary to policy.
True,
If-
yes. Yeah,
So that is the,
that is the only issue. But since it is a policy, my lord, if it's a plenary legislation, probably, my lord, I would not have. My lord, I leave it to your lordship. But I thought, otherwise, we will be in a gridlock.
any subsequent development is there pursuant to your decision?
No, there is, lordships have granted stay, there is no further
There is
construction.
no
There
further.
is no further
Any
construction.
report is subsequent?
Report is, report on what, my lord? The report filed by?
No,
Private,
expert report.
it is
Intact.
private report. but
Yeah, intact report is.
Any subsequent orders are passed by the court?
My lord,
No,
No.
not thereafter.
Subsequently, this honorable court has passed an order.
What?
You can proceed with the repairs. That is in the
Not on construction.
construction, repairs and all
Repairs
you
only.
can continue. That is in the connected writ petition.
No, on this also, I'm not saying, I'll have to get instructions. New year. Council. But the rule called as the Ancient Monument and Architect Sites remains rules 1959. Rule 34 says, application for license. Every person intending to undertake any mining operation or any construction in a regulated area, which is the from 100 to 200, shall apply to the Direction General in Form 6 at least 3 months before the date of commencement of such operation. So that's the difficulty. Now, my lord, if I follow this rule, I cannot, my lord. I will have to refuse. That is what is holding back. My instructions are, my lord, if your lordships exercise power under 226 and direct us to consider, my lord, then.
And my lord, the Supreme Court has held, permission need not always be prior permission. You can seek a permission.
This is within the regulated area or not?
This is
regulated.
regulated area.
So then how? can-
About approximately about 192 meters. So it's on the farther side of the regulated area.
Within 200 meters is a regulated area. It is at a distance of 100
So
and.
can you, as an authority, re-examine the feasibility of?
My lord, I have to just give a NOC or I have to give my consent. But I'm bound by, my hands are tied by this.
Which
rule
can be the
34.
independent body or agency or committee which can re-examine. Because the report they have produced is a private report by expert engaged by them.
My lord, it is recognized by the ancient, the department itself recognizes intact and they recommend intact. The report, my lord, they recommend intact because it's in only.
My lord, if your lordships want us to examine whether this building, if constructed from ASI perspective, whether it affects the monument, my lord, we can file, my lord. We have not done it. The report now is by a private agency.
Yes,
We
you can
do that.
you can do that.
I can do.
Under which provision?
Under the provisions of this very, the rules read with the national monuments, the ancient monuments. As an authority, my lord, as an authority,
This place is, collector is there or who is there?
There is a deputy commissioner of the district. my lord.
Commissioner
Yes, commissioner. We call him deputy commissioner.
Commissioner.
Yes, yes.
of which is the place?
This is a place called Mudbidri, which is within the Dakshina Kannada district. my lord.
Which is the place?
Mudabidri.
Lord, this place
It's
is
a
Mudabidri,
place is
but the
Mudabidri.
district is Dakshina Kannada, primarily Mangalore.
No, if we want, we are inclined to depute a team or appoint a team headed by the commissioner, consisting of 2 other members,
Please, my
who may assess the amount spent in the existing construction.
Very well.
And also want to require you to
Very well.
find out by submitting a report whether it is feasible or not.
Lord, I'll ask the ASI to give a,
On next day, we'll pass that out.
very well,
please, please.
3 weeks.
It is, that is what we are asking, municipal council.
I am the municipality, my lord. I am appearing for municipality. Deputy commissioner is the. Hmm.
So you just gather instruction on the next day in the presence of everybody.
Yes.
When
I'll
shall
do
it? Monday, Tuesday, Wednesday, or any other day.
Tuesday, my lord, because the municipality.
Mr. Kamath will need little longer.
I'll need little longer.
Because he will take comprehensive instructions about.
Yes, Lord.
please.
On 2 things, my lord. One, I'll find out whether it mars the, this particular monument. Secondly, my lord, I'll also find out if I can consider the NOC as though no construction is made.
Correct. Correct.
By stipulating what are my conditions.
Yes, that is also better.
True. Otherwise, we will remain at a gridlock and I
And
think
this
the
is
people of the town will suffer.
marginally inside,
Yes, my lord. Yes,
very marginally inside.
very
Very
marginally. And in between, they have filed a list that in between this building and the ancient declared monument, there are about 400 constructions which have come within the prohibited area of 100 meters. No action is taken, just for
This
the,
is outside prohibited area, but inside regulated area.
Yeah.
it's
Precisely,
within the,
precisely.
yes, ma'am. That's what,
Precisely.
yes,
We'll find out some way.
please,
We'll find.
please.
Some
This-
logical, legal way.
True, I mean, it's better to adopt a pragmatic approach in this.
So whenever you say, we'll just post.
About 2 weeks. ನಿಮ್ದೇನೋ ಡೇಟ್ ಇದ್ರೆ ಹೇಳಿ. 30th ಯಾವ್ದು ಆಗಸ್ಟ್? ಇಲ್ಲಿ ನಮ್ಗೆ ಐ ವಿಲ್ ನೀಡ್ ninth August.
9th is holiday. No,
8th.
9th is not holiday.
8th or 9th?
8th or 9th, whenever.
Yes. 8th.
8th.
Similarly, at 2:30.
I will take.
Please. I'm good.
My lords, my lordships kindly leave, my lords. My lords had mentioned in the morning, my lordship had told if. So clarification, my lords. In the morning, I had mentioned, my lordship had told it, if it doesn't, my lords, there's urgency, that's the reason. My apologies, I'm mentioning time and again.
Where is the other?
To inform me. Yeah, my learned friend is there.
You just refresh and will dispose of the main matter itself.
My lords, only for my lords, the reason, my lords, only with respect to clarification now, my lords, learned senior counsel is online.
My learned
No
friend,
point in dealing with piecemeal.
No, my lords, here, my lords, the reason why we call my lords, because the main matter with respect to the pleasure doctrine, my lords, that here may not arise right now because the term of the body itself is over. We just want that clarification because to a reconstitution now, my lords, because by virtue of the interim order that we don't want to, we just sought for
I thought,
clarification
my
of the
lord,
interim order. In
great,
fact,
with fairness to my other side, the learned counsels were present on the other side. We had said it will be heard on main. And today my learned friend
Not-
mentions at 10:30 to say
no, my
clarification.
lords, we have filed application for
He
clarification.
had said that will be.
It was,
My lords, for clarification, we have filed,
Every
my lords.
time-
My only, my lordship may only clarify to that effect, my lord, that interim order will not come in the way.
What is wrong if we dispose of finally within 2-3 days?
No, my lords, the right now the body is, my lords, the term of the body is over. We are not able to function. No inspection, no affiliation, the body,
Instead of clarifying by interim order, why, what is wrong if?
my lords, in the body which was there, what they're asking that they are the members of that particular body, that body is dissolved.
Dissolved.
I mean,
That's,
that
my
for that
learned
period,
friend.
I'm sorry, my lord, that
Exactly
is
what
over.
happened
That
last
is
time.
over, my lord, that period,
Then
3 years.
You do whatever you want to do in a.
Please, my, that means the interim order here, my lords, my lords, the interim order granted should not come in the way.
We are inclined to dispose of the main petition itself. How can you insist that, no, pass?
No, my lords, I'm not coming in the way with respect to disposal of the main, my lords. The interim, order, we have just filed an application for clarification that the interim order should not come in the way of reconstitution of the case.
34.
Which IA you have filed?
That's my
2 of
senior
20
counsel is online, my lord.
2 of 24? Seeking clarification?
Please, my lord.
Yes.
My lord. Let's see, Mr. Senior counsel is online, my lord, so he'll take over. Mr. Nayak is appearing. He's online. He'll address arguments on behalf of the university.
All of you may do one thing, you just briefly remind us the argument and we'll keep it for final orders.
Please,
Today,
please, my lord.
all right.
Lords, your lordship, might kindly take the writ appeal, my lords. 635 of 2024.
How many appeals are there? 3.
Lords, I appear in only one, my lords.
Yes.
There are other counsels in the other connected matters. So I'm not aware whether they are present here. No, my lords, issue is relating to nomination of
You have
members.
given the written submissions?
Lords, we have not filed. I can.
You
have not.
prepare it and give
Please.
tomorrow?
Please. I'll
Tomorrow,
do that.
short synopsis.
Short synopsis.
Till 2:30 will take.
Tomorrow 2:30, please.
We'll file it in the court across, my lords, tomorrow, the written
Give
synopsis.
in course of the,
Please.
at the time of.
Yeah, 7.
87.
May please, your lordships. I appear for the petitioner in this matter. If your lordships recollect, in fact, the learned advocate general was supposed to address your lordships, which in reply to our arguments.
Where's the code copy?
Have it.
Principle of natural justice.
Section
6:2.
Give me the act. With your lordships kindly. Yeah. Can I give a convenient compilation, written submission note? The impugned order, man.
Page 30.
Give him one copy. Lordship, may kindly turn to the, I produced a copy of the Water Act, which starts at page 6, my lords. So that page 6, the relevant portion is at page 12, my lords. 12. Section 6. Page 13, 1-3, my lord.
He is civil servant.
Please, my lord, this period is still in the month of November, my lord. No, he's not a public servant. He's not a civil servant. He's a public servant under the act. His appointment is under the act. He's a public servant, but not a civil servant. Civil servant through civil services, my lords, who comes, is a statutory appointment for a period of 3 years. That's all, my lords. And his removal is also under the act, my lords. In fact, the judgment directly covering this, on this aspect, whether Article 311 is the, it says it
According to it, not apply.
does not apply at all.
Question is, even if 311 doesn't apply,
Please.
what procedure you are supposed to follow?
And that, I'm coming to that itself. I'm answering that directly. That's why I'm taking,
That's the only point.
that's the only point I'm going directly to that itself. And judgments on that itself, my lords. Can I request page 13, my lords? 1-3 of the compilation, my lords. Section 6 speaks about it. Speaks about disqualification, my lords.
So, any employee in private employment or semi-government employment. to
Under the
whom-
pollution,
To whom 311 doesn't apply.
please,
Or any employee like the present petitioner, to who, which is a statutory appointee.
please, my lords.
And his condition of removal, etc., is governed by section 332.
6(1)(g). Identical facts.
Is he not entitled to the bare minimum principles of natural justice?
Yes, natural justice, whether natural justice requires personal hearing or not, is dealt by this court already while deciding section 6(1)(g).
Not personal hearing, framing of charge.
Now, that is not required. That is what has been answered. my lords. Framing of charge is also not required.
Is there any judgment?
Yes, direct judgment is there.
Direct judgment.
On division bench. I'll just come to that. Page 13, my lords.
Page 13.
disqualification, my lords. No person shall be a member of a board. Clause 6G, clause 1G, my lord, has so abused in the opinion of the central government or as the case may be of the state government, his position as a member as to render his continuance on the board detrimental to the interest of the general public. What is very important in this is, my lords, it's subclause 2. What it requires is, 2 is no order of removal shall be made by the central government or the state government, as the case may be, under this section, unless the member concerned has been given a reasonable opportunity.
So what is the scope of this phrase?
This
Reasonable opportunity.
reasonable opportunity. That's the thing, madam. This came for consideration, 1G and 2 came for consideration of the division bench of the Manipur High Court, madam. It says that represent opportunities if a reply is given and that has been considered, madam, that is sufficient. Procedure has been followed. What is very important is, my lords, if your lordships can see the section 21 and section of this very same act and 28 and 29 speaks about opportunity of being heard. Section 21, 28 and 29 speaks about opportunity. Your lordship may kindly take page 6 for a moment, my lord. Page 6, can I request, my lord? Page 6.
Page 6.
Page 6, that is, my lord, that's the index, my lords, to just to, for your lordship's convenience. Section 21 is the last section, my lords. Section 21. 21, power to take samples, effluence, procedure to be followed in connection therewith. Then 28 at next page, my lords. 28 and 29 speaks about opportunity of being heard should be given before any order is passed.
That is regarding consent, etc.
Please, my lords, this is, if I may. Give a copy to me. Very good, very good. Your lordship may kindly say the reasonable opportunity of showing cause as against reasonable opportunity of being heard. Section 5(3) terms and conditions of service, 6(2) disqualification says after giving him reasonable opportunity to show cause. As against that, my lord, reasonable opportunity of being heard is mentioned specifically in these sections. Is appointment order under which section?
5(1).
The petitioner's appointment, my lords, is under section 4(2)A, my lords. Page 11. Section 4(2)A, my lords, under section 11. The term of office is a section 5, which is for a period of 3 years. Section 5, my lords, save as otherwise provided under this act, a member of the board other than the member secretary shall hold office for a term of 3 years from the date of nomination. So therefore, my lords, it is a case of nomination, my lords, where he holds for a period of 3 years. So therefore, my lords, reading section 4(2)A, my lords, and section 5 and section 6, my lords, what is contemplated is only, my lord, before his the removal, as it says in 4(2), no order of removal shall be made by the state government unless the member concerned has been given reasonable opportunity. As the lordships were pleased to point out, what is this reasonable opportunity of showing cause against this been given, my lord? Whether that has been done or not is a short question. Please, Madam. I'll just take your lordship directly to the citations, Madam, then I'll come to answer your lordship's query, Madam. Can I request page 23, my lords? Page 23, paragraph 3, my lords. Writ petition has been filed by the appellant to quash the order dated to 20 so and so, thereby terminating the service of the appellant as chairman of Manipur Pollution Control Board and appointing the third respondent as the chairman, Manipur Pollution Control Board. In this case, my lords, your lordships had, this is a case only of termination. Then if I may request, my lords, if I lordship turn to paragraph number 15, page number 26, my lords. Page number 26. My lords, they got page number 26, my lords.
Yes.
Paragraph 15, my lords, 1-5. The case of the appellant before the writ court is that he was nominated as chairperson of so-and-so on 23rd to 3/2017. Thereafter, the MPCB was reconstituted on 30th July 2021. The appellant has to continue for another period of 3 years from 30th July 2021. On 14/7/2022, the third respondent was appointed as chairman and the said order was assailed in WP number so-and-so. The writ petition was allowed by the order dated, whereby the order dated so-and-so was quashed and the government was given liberty to reconsider the claim of the appellant by affording reasonable opportunity and also by following the procedure as contemplated under section 5(3) or 6(2). This we are concerned with 6(2), my lords here. 6(2) of the Act of 1974. On 9/9/2022, show cause notice was issued to the appellant, thereby charging him of appointment of 107 posts made in the board without the approval of the state government, and he was asked to show cause why disciplinary action should not be initiated against him. On 16/9/2022, the appellant has submitted a reply to the show cause notice. However, without taking into consideration the reply, the state government has issued the order dated so-and-so terminating the appellant from the post of chairman and appointed the third respondent in his place as the chairman. That is the contention. This is the contention of the appellant's identical contention. Here also, my lords, his contention is identical. Para 18, the appellant has assailed the order dated 20th September 2022 before the learned single on the following ground. As the tenure of service of the appellant chairman so-and-so is 3 years, with effect from the date of appointment, they cannot terminate the service of the petitioner before completing the tenure of his service. The order dated so-and-so to complete violation of the single judges. Point number 3, the appellant was not committed any irregularities. I skip that, my lord, the scale of so-and-so. Then, my lord, the finding is at page 34, paragraph 39, my lords. Page 34, paragraph 39. After considering the submissions, the learned single judge held that there is a fallacy in the said ground raised by the appellant. When we peruse some of the appointment orders filed along with the present appeal, we find that the appointments were made in the year 2008 and not in 2021 pursuant to the judgment of NGT. That apart, the directions of the NGT was relating to filling up of vacant posts in the State Pollution Control Board. The state has noted that the arbitrary engagement appointment without authority carried on by the appellant before the order of the NGT in his capacity as chairman without following proper norms. The fact remains that the appellant had not submitted the proposal to the state government for engaging the existing vacancy of the board. The said view taken by us is strengthened by seeing the representation dated so-and-so and the reminder representation dated so-and-so submitted by the respondent so-and-so contractor, wherein the employees have sought for regularization of the service. I'll skip that, my lord. Then I request page 35, paragraph 41, my lord. The first respondent state contended that the respondent number 3 is more qualified than the appellant for consideration of the appointment to so and so, so and so. Then, my lords, last 4 lines, since the appellant has abused, para 41, last 4 lines, since the appellant has abused his position as chairman and made illegal appointment, he was terminated under the order dated so and so. The learned single judge held the termination was valid, and we have affirmed the said view of the learned single judge in the earlier paragraph. Paragraph 42. It is reiterated the state government, after examining the candidate in the light of the material connected with the issue that the appellant had abused his position in making illegal appointment, that he is no longer suited for the appointment, decided to appoint the third respondent as the chairman of so and so. Paragraph 44 is the crux of the matter, my lords. Paragraph 44, page 36, my lords. Next page, my lords. Page 36. Paragraph 44. This is very important, paragraph 44. We have thoroughly gone through the order dated 11/8/2022 passed in WP in paragraph. It has been held that removal of a chairman is permissible only after observance of the principle of natural justice, to which after giving a reasonable opportunity to show cause. And thereafter at paragraph 22 issued a direction. A state, as stated supra, state government has observed the due procedure as contemplated under 5.3 and section 5.2 of the Act of 1974, as well as the rules prescribed for appointment of the chairman a date before termination of the appellant, and after giving suitable, after finding the suitability of the third respondent, the state government has rightly appointed him as the chairman. In view of the above, the appellant cannot contend that he is entitled to continue as so and so. Here, the procedure followed also was, my lords, notice under 6.2, opportunity to reply, then an order came to be passed. The question of, in fact, what is important, if your lordship may kindly see, my lords, the order, annexure, what to say, notice under section 6.2, at annexure N, page 161 of the writ petition, my lords. Annexure N, 161 of the writ petition.
This is last show cause notice.
Show cause, last show, I vote on to your lordship, last show cause notice. Your lordship remembers the. Your lordship making so and so additional state audit account was authorized by the government notification dated 26. This is important, my lord. Page 161, first 3 lines, show cause notice. So and so state audit was authorized in the government order dated 27 July 22 to investigate and report on the violation of the provisions of so and so in the activities undertaken to create awareness, awakening the environment protection and pollution. After verifying the information, documents provided by the member secretary, Karnataka State Pollution Co. investigate, the corporation audit appointed by the government has submitted an investigation report along with the supplementary documents to the government. A copy of the investigation report is enclosed herewith. My learned friend made a submission that the copy of the investigation is not given. It is clear from the investigation report that you have misused your position and authority has committed following irregularities and misconduct by violating provisions of the Karnataka Public Procurement Transparency Act 1999 in the activity of undertaken to create awareness, awakening the environment protection and the pollution control. Section 4B of the Transparency Act should only be used if a particular supplier or contractor has full rights in relation to the goods or services or works and no reasonable alternatives or suitable exist. But in the background of the confirmation that the other organizations are eligible and available for advertising contracts, method adopted by the board that have been considered illegal as a sole source organization. Point number 2, consistency of committee of selection of single source organization, so and so acting. If I may stop here, my lord, what the appellant does is, my lords, under the act, he is permitted to tender only less than 25,000. As per the water rules, only less than 25,000, my lords. What he does, my lords, but there's an exception under the Transparency Act, but if there's only a one tender, one eligible person, they can be called and given. So to worth nearly 10 to 12 crores of rupees, my lords, what he does is, he uses the Transparency Act. He doesn't constitute the committee, my lords. He says that so-and-so is the only eligible person and gives the contract of advertisement worth 10 to 12 crores to one individual. That is the inquiry and the finding, my lords. To circumvent the act and the rules so that it doesn't go through the transparency, Karnataka Procurement Act, he award the tender of 10 to 12 crores to the people whom he wants. The Water Act, my lord, your lordship may kindly see that his restriction is to the tune of rupees 25,000. That is section 4, section rule 15, I think. Your lordship may kindly take the compilation page 43, my lords. Page 43.
But you are acting at the stage of allegation.
Please, my lord.
You are acting at the stage of allegations. They have to be proved. How you can act?
No, that is why inquiry was conducted. We have given him the report and he does not deny that.
Which
Yeah.
report?
The inquiry report is given to him. My lord?
Self-made investigation.
Yes.
Not an inquiry.
No.
Crime fault,
No.
to answer charges.
Where
It is
the
not-
law does not require him to give him an inquiry. We did an internal inquiry to satisfy us whether the allegations are true. Then we placed it before him, you answer it. He is given a reply to it. In the reply, it's a virtual and admission in the reply.
That inquiry was conducted.
Not inquiry, my lord, the law does.
Some inquiry was conducted. After giving show cause notice, what did you do?
Investigation was done.
Where is that report?
That R7, annexure R7, page number 56, part of our statement of objection.
Not a single penny has been dispersed, your lordships.
It's all in Kannada.
Annexure R7.
R7, my lord, the translated copy starts at
90.
page 90, my lord. 90
Of your reply.
of my statement of objections, my lord.
That is.
This inquiry, this is an investigation report which is pre-show cause notice.
Correct.
Pre-show cause.
There's no requirement in, my lord, what is to be required to be complied is as per rule, section 6(2), my lord. Section 2, 6(2).
Where is your report?
Report is
Page
at page
90.
90. The impugned order, my lord.
Report, page 90.
Page 90, my lord.
That is pre-show cause notice.
Pre-show cause notice. There's no dispute on that, my lord, because my show cause notice itself encloses this report. My learned friend was, my lord, your lordship may kindly see that is not his case. From the grounds raised before in the petition, my lord, he does not. So as your lordship said, whether inquiry is to be done is one legal aspect. The law does not contemplate for an inquiry in case of an appointment under the Pollution Control Board whose tenure is 3 years, whose case is a case of nomination, my lords, for a period of 3 years. The question is whether he has abused. I give him a reasonable opportunity to reply. What your lordships will examine, my lords, is whether we have given him a reasonable opportunity. He is given a reply, neither he has asked for an inquiry, he neither asked for an opportunity of hearing. He should have filed in his reply, let an inquiry be conducted. He doesn't say that. He doesn't ask for an opportunity for hearing. Neither in this pleadings, he says the inquiry ought to be done. That is not his case at all. It's an afterthought which is just sprung up just now. There's no reply seeking for an inquiry or for a personal hearing. And the law also does not contemplate that. Neither in his pleading, he says the inquiry ought to have been conducted. And the Manipur judgment of division bench clearly says, my lords, notice, reply, and order. And one more thing, we have gone, it's not that we have done it overnight, my lords. This inquiry report was thought to be challenged before your lordship. This court has upheld it. investigation. I'm sorry, as my learned friend, this is not an inquiry, it's an investigation report which we have enclosed it. Your Lordship may kindly turn to page uh, hmm? Page 97. Page 97. Petitioner so-and-so has challenged the communication dated 26/7 whereby inquiry is initiated against him for alleged page 97 of the writ petition, my lords. Can I request 97? I'm sorry, I should have made myself clear. I should have told that. Page 97 of the writ petition. The judgment starts at page number 42. The petitioner Shant Etimaya challenge to the communication dated 26/7 whereby inquiry is initiated against him for alleged lapses. I'm sorry.
Yes, it is there.
It is there.
So it is in which petition?
That
The order is passed in some, by division bench.
division bench, that your lordships will get it at page 42, my lords.
So this is the order, impugned order?
No, my lords. What?
Your Lordship, this is the order of affirmation of.
This is petition.
No,
This is direct
page
petition.
42.
Page 40, page 97 is we part of which order, which proceedings?
Wherein is
A
challenge
part
the
came up to
inquiry
the Supreme-
proceedings, my lords.
He,
Petitioner challenged the inquiry proceedings with regard to arising of this very proceedings.
And
This
the
is
removal, your
referred in the
Lordship. In
show
fact, there
cause-
were
this is
seven
referred in the
petitions. There were
show cause
7
note.
petitions.
you will challenge the investigation report.
Yes, your lordship may kindly turn to page 161 now, my lords, page 161. No, not 160, my statement of 161.
Notice under Transparency Act.
One-
In our,
No, let me complete what the, I'll answer the quote, then we can explain.
So this page 94 is in some PIL.
No, page 161 for a moment, your lordship may kindly hold page
please, your
161.
Lordship is right. In fact, it's in a PIL which had actually challenged my, let's say,
My
appointment,
learned
your
friend is trying
Lordship.
to detract. Let me answer, let him argue. So I'll
It came
just
up with the
answer the.
Supreme Court, which, okay, which the Supreme Court also said, okay, let him continue till 14th of November.
Let him complete.
Page 161, let him answer that. I am not coming in this way. Page 161. Page 161.
That is show cause notice.
Your lordship may kindly see the third line over there, my lords, in the 161. Mahadev additional auditor, order dated 26 July 2023 to investigate and report on the violation. This order was challenged, my lords, in the PIL, in before this one.
Where you reading?
Page 161, my lord, third line. This order dated 26 July 2023. This investigation.
This was challenged.
This was challenged. That your lordship will get it, page 91. That is what they wanted your lordship not to understand. Page 97 now, my lords. Page 97. Page 97. The petitioner challenged the communication dated so and so, dated 23/6/7, whereby inquiry is against him for alleged licit and divide of money is liable to be accordingly dismissed, and consequently said the inquiry shall be accomplished in accordance with law. This court division bench say that go ahead and conduct the inquiry in accordance with law, which has been upheld by the Supreme Court. My learned friend saying that it has to be continued till 14th of October. There's no such order.
So this is upheld by Supreme Court.
Yes, that is my lord's next page.
This division bench.
Yes.
This
At
division
page
bench is
99.
Supreme Court said it refused to interfere because term
No,
was
whatever
expiring on
the Supreme
14/11.
Court refused to interfere with
Yes.
this
So then what is in accordance with law?
accordance with, I'm coming to that.
That's all.
6-2.
What is in accordance?
Therefore, 6-2. What does 6-2 say?
This is the whole point. Again, we are coming back to
Back
this.
to the same.
No, so therefore, my lords, again, what my learned friends try to say is that what is the opportunity should be given.
Now consider the private employer
My lord,
making some allegation against some employee. Say of defalcation, misappropriation.
What-
Issues not in
my
conduct.
lords, I would say a private employer is an employee, is not an employee, is a nomination for a period of 3 years. Here the statute provides for removal.
Is nominated.
Nominated for a period of 3 years. Now what what is unlike other matters.
An employee or no?
He's not, my lord, he's a public servant for a period of 3 years as per section 5.
He's an employment or no?
He's not an employment, my lord. He's on nomination. My lord, it's employment and the pollution code board is a separate set of employees of the pollution control board, my lord. In that case, my lord, is it a contract for a period? I would say it's a contract for a period of 3 years.
All right, contractual employment.
He's a
My
public
lord,
servant.
your lordship may kindly see.
Is it an employment or not?
It is, in other terms, it is an employment.
In loose sense, it may be an employment, my lord.
It is an employment.
Section 50.
So pollution control board is a public employee or not?
My lord, your lordship may kindly see what is the scope of his employment or whatever.
Is nominated to serve with the.
Your lordship may kindly go to, can I read section 5, my lord?
Section 5 of the act.
The same act at page 12, my lord. There's a, can you, lordship may kindly read section, can I permit you to read section 4, my lord? What is contemplated, his legal position in the board is of a member. As per section 4.2, a state board shall consist of following members. Member including chairman. Chairman is one of the member who is appointed in terms and conditions of section 5. So therefore, my lord, being a member who is nominated for a period of 3 years,
So he is not an employee.
is not an employee in that sense. Being a member of a board by virtue of a nomination. No, that's no problem. He's a member.
That is appropriate. He's a member of a board.
Board. Member means member of a board, including the chairman.
So he is not in employment.
No.
He will not be in the roles of, their role of,
Which is it? Take it on. Section.
board. Here.
So here you investigated.
Please, my lord.
You investigated the allegation. Then give the show cause notice.
Please.
And then dismissed, then removed.
He's given a reply, my lords. After the reply, my lords, we pass the order. Because, in fact, my lords, we have given him reasonable, it is not his case in his reply notice saying that I need one more opportunity, I want one more hearing, or I have to give one more reply. If your lordship sees the date, my lords, 29/12/2023 is a show cause notice issued to him. He has replied on 17th January. The impugned order is passed after 4 months, my lords. The impugned order is passed after 4 months. In the period of 4 months, my lords, he doesn't say that kindly conduct further inquiry. I have further reply to file. Give me an opportunity of hearing. All that is not this case of principle of natural justice. Is never raised. So, and the investigation report was enclosed to the show cause notice. Page 1614 once again, my lord, if I may show, point out one. My lords, here is a case, my lords. He doesn't have the power to appoint member secretaries. He goes ahead and appoint member secretaries. He removes member secretaries when he wants. It is the power of the state government to do it. A tender, as per section 15, page 16, my lords, his amount, he can call for tender only 25,000. He goes and calls tender 17 crores. I'm sorry, 17 crores tender is called by him, given to one person, my lord, saying that he is entitled to do it for advertisement. My lord, this is nothing but clear abuse of his position. That is clear from reading of section 6(1)(g). The question is, what is the procedure to remove a member is under 2. We have offered him an opportunity, my lord. That's all that is required in contemplated under law. He doesn't have a vested right, my lord. What is his vested right to continue in that post when he has
There is no question of vested right.
no, wow, the question is if he had, being a member, my lords,
Only thing that you are stigmatizing somebody.
not, the law requires that. That's why I pointed out, wherever the section requires question of personal hearing, we have given personal hearing. If a person has abused his position, my lord, the law requires, as contemplated under the statute, is only giving him a reasonable opportunity.
Any judgment on the scope of
That is, I've placed that also, my lord. I'll
Manipur.
come.
Manipur is not that explicit.
On facts, it is same. I bow down to what your lordship.
Facts, yes.
I bow down to your lordship. That's why I produce judgments which are more explicit subsequently, my lords. I'll just go through those judgments also. As your lordship said, in similar circumstances, whether opportunity of, my lord, if a person does not ask for a principal opportunity of hearing, the question of giving does not arise. And before your lordships also, he doesn't say what is that he wanted to say, which he could not say, which is not considered. It is not, no prejudice is caused. I understand. He says that I had to say 1, 2, 3. If I had gone there and I had told them, I would have explained to them. I have personal hearing. That is not his case. It's not his case. Even in a case where the opportunity of principal natural justice has been read out, if no prejudice is caused to him, hearing need not be given. Those are the lines of judgment. Assuming, my lords,
Where are those judgments? Let us see.
my lords, just my learned friend wants me to just the compilation, my lords. Section 4(2) for a moment, my lords. Can I request the definition clause, my lords? Board means central board or page 9, my lords. Page 9. Page 9 of the compilation, compilation which I gave with the list of dates. Go to that board, then member will go.
Board and then member. Page 9.
Page 9. 2A, my lords, defines board. Board means central board or state board. Page, port officer, port officer. My lords got it, the compilation. This is a list of dates compilation.
Yes, it is there. No.
With the acts and rules which have.
Anyway, you are reading what?
The act, my lords.
Act, we'll read from it.
Please. 4(2), my lords.
Yes.
2A, board means central board or state board. Member means member of a board includes chairman thereof. Then H, my lords, state board means State Pollution Control Board constituted under section 4. Then section 4, if I may request, my lords. 4.2, page 11, 4.2, the court has got that. The state board shall consist of the following members: chairman being a person of special knowledge. Then B, my lords, such number of officials not exceed 5 nominated by the state government to represent the government. C, such persons are not nominated by the state government amongst the member of the local authority functioning within the state. Such members, D, members of non-official not exceeding 3 nominated by the state, 2 persons representing the company. So it is a board, my lord, it is not, they're not employees in that sense, they're members of this particular board which has been constituted, my lords. And they continue, what is F? A full-time secretary, so and so. 3, every state board shall be a body corporate. This is important, my lord. It's a body corporate within the name specified in the state government in the notification, having perpetual section and common seal, so and so, so and so, so and so. Therefore, you are answering your lordship's query, my lord, with Article 311. This board is a body corporate. It is not within, doesn't fall within the service, my lords. So therefore, my lord, that argument of Article 311 also goes to the wind, my lords. Clause 5.5, a member of a board other than the member secretary shall deem to have vacated his seat if he is absent without reason sufficient opinion of the board for 3 consecutive meetings. So therefore, my lords, by virtue of statute, they go. So the question of they are not employees, the question of principle of natural justice or inquiry, my lords, before removing them does not arise at all, my lords. Those principles does not apply in appointment, because, my lords, it will have far-reaching implication to all other statutory board, my lords. If a person has to be removed under a similar circumstances where he has abused his position, my lords, if an inquiry will be sitting there till the inquiry appeal. So therefore, for 3 years, he is easily able to drag on, even if he abuses his power under the pretext of an inquiry. In fact, it may go to 6 years, it may go beyond the term of 3 years. That is what was not contemplated or visualized when section 6.2. So therefore, at the caution, what is contemplated? Reasonable opportunity of showing cause against the same, only showing cause. Assuming, my lords, I'll go to it is ultimately, my lords, it is my satisfaction of the state government that he has abused his position. Now, calling for thing is given a reply, my lords. So therefore, that is one aspect of it. Then coming to the judgment next, my lords. Page 85, my lords, second proposition. To show that he has violated KTTP Act. No, which one? Page 37. Chairman is not a board.
Page 20, paragraph 23.
This report was given to him.
Yes, page 161, my lord, page 161. Yeah, in fact.
Along with show cause
notice. Yes, page 161. I'll read it. My learned friend has been telling me to read it again. Page 161. Page 161, last 3 lines. Page 161. Annexure N. Show cause notice dated 29th December 2023 of the writ petition, Annexure N. The last 3 lines, my lords, Annexure N, page 161. 161, last 3 lines. Shri Madhav has submitted the investigation report along with supplementary documents to the government. The copy of the investigation report is enclosed here with this notice. Page 161, my lords, last 3 lines. My lord, in the investigation report is a comprehensive investigation report along with the show cause notice. We have given him to everything and he has an opportunity to reply also. So therefore, my lord, that is placed, he is fully aware. That is what is contemplated under section 6(2). And we have considered and passed the impugned order. They do not find fault with the impugned order, neither the show cause. In the reply, they do not say this is not given to me. You only send this notice. All in the petition also, they do not say.
Page 60, paragraph 24 what?
Then, my lords, if I may take the compilation of third judgment in the compilation of judgments, my lords. That is at page 60, starts at 37, my lords. Therefore, it is clear that the period of natural calamity or emergency declared by the government, page 60 in the compilation of judgment, my lords. The judgment starts at page 37, my lord, 37. What have given? I've given it. Given it. Page 37. The ILR 2008 Karnataka 3787. Relevant page is page 60, para 23. My lords got it, my lords, page 60, para 23. Therefore, it is clear that during the period of natural calamity or emergency declared by the government for procuring goods or services, it is not necessary to follow the procedure prescribed under the Act. The second exception to clause B is that when there the goods and services are available from a single source or where a particular supplier or contract has exclusive rights in respect of a goods or services or construction work, no reasonable alternatives or substitute exist. It is not necessary to follow the procedure prescribed under the Act. Therefore, there is no obligation to procure under such services and goods by inviting tender. But this is important, my lord. But before this provisions could be invoked, there should be a finding by a competent authority that the goods or services are available only from a single source or a particular supplier or a contractor who has, page 61, or who has exclusive rights in respect of goods and services. For that purpose, the statute provides for constitution of committee of 3 experts consisting of the following persons. I'll skip that, para 24. The third experts have to be drawn from 3 different sources as mentioned in the provision. The significance of the same is that 2 of them are not under the control of the procurement entity. That is how the public interest is protected and transparency is achieved, even in exceptional cases. Therefore, all the aforesaid persons, that is the technical person, must be expert in the field. It is a committee consist of these experts alone, which on consideration of the goods and services are placed before it, can declare that the goods or services are available from a single source. It is after certification by the committee of experts in the field, the procurement entity could place only for orders of supply of goods and from a single source. Therefore, the legislature has taken pains to meticulously provide in the Act itself for the constitution of the committee of experts and for the decision before the regular procedure is dispensed with. Therefore, here what the petitioner does is, he constitutes a committee for himself as a chairman, and he says that, yes, he is a single entity, I'll give to him. There is no expert body who comes to the conclusion. That is at annexure R1, page 17. Your Lordship may kindly see annexure R1, page 17. He is already decided that I'll procure for him. He constitutes a committee under his chairmanship and gives the contract in one single document of worth nearly 17 crores, and he makes this committee valid for 1 year. So over a period of 1 year, my lord, he keeps on giving single entity contracts. That is nothing but abuse, my lords, and causing huge loss to the state exchequer. Next judgment, my lords, if I may request, page 85, my lords. Page 85. With regard to opportunity of hearing, whether it's to be required to be given, my lords. This is a case, my lords, where the age of a judge, my lords, was thought to be changed. The case of the honorable judge was that he should have been given an opportunity of hearing before an order is passed, my lords, in view of Article 207, subclause 3. 217, subclause 3. So Supreme Court held, my lords, the question of giving opportunity of giving hearing is not required, my lords. Para 26, that your lordships will get it at page number 95.
96.
Yeah. Which one? Para 96, page 20, para 26. Page 96, para 26. Article 217(3) does not guarantee a right of personal hearing. A procedure of judicial nature and the basic rules of natural justice must be followed. The respondent was on that account entitled to make a representation, but it is not necessary an incident of rules of natural justice that a personal hearing must be given to a party likely to be affected by the order. Except in the proceedings in courts, a mere denial of opportunity of making a oral representation will not without more vitiate the proceedings. A party likely to be affected by the decision is entitled to know the evidence against him and have an opportunity of making a representation. He, however, cannot claim that an order made without affording him an opportunity of personal hearing is invalid. The president is performing a judicial function when he determines a dispute as to the age of a judge, but is not constituted by the Constitution a court. Whether in a given case the president should give a personal hearing is for him to decide. The question is left to the discretion of president to decide whether oral hearing should be given to the judge concerned. The record amply supports the view of that the president did not deem it necessary to give a oral hearing. There is no complicated questions to be decided by the president. On the other hand, there was evidence of matriculation certificate and representation made by the respondent before the Board of Commissioner in the United Kingdom, where the respondent submitted himself being admitted to Indian Civil Service examination. On the other hand, there was evidence of the assertion made by the respondent he was born on so and so and so. I'll skip all this. So therefore, my lords, even in a case of judge, the question is whether the material was sufficient. The only material is annexure R1, my lords, and therefore there is no prejudice caused to him or there's nothing more. In fact, that was not argued, it is not pointed to your lordship by giving not an opportunity of oral hearing, how he has been affected. That is not his case at all. And so therefore, my lords, all case of principle of opportunity of hearing cannot be stretched to say that, my lords, in all cases of principle of natural justice, principle oral hearing is a must or mandatory requirement, my lords. Next is page 101, my lords. That is at paragraph number page 101, division bench of this court, page 101. Can I request, ma'am? Judgment starts at para page 101, page at 106, my lords. Page 106. Para 18, Reliance was however placed on two other rulings of the Supreme Court in so and so, so and so, so and so. The effect of which seems to be that may be desirable to give a hearing is in complicated case, though it may not be obligatory to do so. But the proposition of law clearly stated in the second case is, in the proceedings of judicial nature, the basic rules of natural justice must be followed. The respondent on that account is entitled to make a representation, but it is not necessary an incident that rules of natural justice, the personal hearing must be given to a party likely to be affected by the order, except in proceedings in courts. A mere denial of opportunity of making oral representation will not, without more, vitiate the proceedings. Para 19. Although what is stated above makes further discussion on this point unnecessary, we might observe that there is not, in the nature of things, any compelling necessity to give personal hearing under section 115 of States Reorganization Act. The principles already stated are to equate the post and next to the count the length of service. The basic principles of equation have also been clearly stated. The material necessary for application of those principles obviously available in its entirety in the records of the government of integrating state, the shapes, recruitment rules, notification for departmentalization of work, investment, delegation. There is nothing on material available which a party may add to it by making oral hearing. Whatever he may have to say can be fully stated in written representation, which he is permitted to make. Para 20, we are unable to see anything special or peculiar difficulty in these cases so as to incapable of understanding a solution without an oral hearing. This is the crux of the matter. So therefore, just because oral hearing is not given or inquiry, it is not required to be done. It's not a complicated case where evidence has to be done, cross-examination has to be done. Each party does not know what they're talking about. It is a clear case where we have put across, investigation report has been given to him. The allegations are there, he has to meet it or not, or he has to say, no, I have complied with it. It is not his case that he has complied with it. He does not dispute all these facts. Ultimately, even if I have abused my position, let me inquiry to be conducted. This one. I just to make it convenient for the court, I just put it in writing. Because we may say and go, it's difficult for your lordships to. Give it and we'll see. Photo. Kindly give it to me. Sign master there. Petitioner's argument are 1, 2, 3, 4. Finding of the allegations. These are the 4 points that the petitioners argued. In the reply arguments I have given in each one of them. First argument, reply argument is this. The second argument, illegal appointment of member secretary made by the petitioner using his position. Third, next page is illegal issuance of ECR certificate. Section 4, fourth point is section 6(1)G. I just put it in a nutshell, so that it's easy.
It does not contain all my arguments. Anyways. The opposite party is saying what my arguments are, does not contain all my arguments. In any case, let the learned AG.
Give your synopsis.
I'll give my synopsis with what
If
are
I
my
can-
contentions, yes. Yes, ma'am.
Can you give a synopsis?
Reply, reply.
Is over.
I'll complete my reply, ma'am. Just about 10 minutes.
You are there.
That I appear for the Position Control Board. So I would adopt the arguments of the state government.
You are for whom?
That I appear for the Member Secretary Position Control Board members.
For the Pollution Control Board, my lord, the orders passed by the state.
It is your stand.
That our instructions are, let's be, our stand is that let's we have taken whatever the state government.
Not to stand up before the court. Neutral.
They will have to toe the line of.
Supposed to be neutral, aren't
Yes, so that's we just assisting by standing.
adopting argument of Mr. AG.
That's to an extent of the documents, that's the documents which the learned AG is relying upon is based from our records, that's. To that extent, that's I said I would be adopting.
But briefly,
Yes,
my lord.
Mr. Reddy.
The short issue boils down to, if I may just crystallize whatever learned AG said and what I've argued. They issue 3 notices. Basically, they have issued 3 notices. Basically, 3 charges. Yes. One is on appointment of member secretary, first one. Which is page number
116.
160. Yes. This notice is not a notice under 6E of Water Act, saying there is abuse of power, therefore I am liable to be removed. This was the earliest point of time when the government decided to issue a notice. It never thought that this is an abuse of power. It did not even say it is an abuse of power. It is not a notice under section 6E. Therefore, my lord, I answered to this notice. Then they never issued another notice on this ground saying I am issuing it under 6E. But in the order of dismissal, termination, they say they treat this as one of the allegations as 6E. This is virtually convicting me or holding me responsible behind my back.
So this was virtually dropped.
This was taken into consideration.
No, so no reply was.
No,
You had no opportunity to reply to this.
no opportunity to reply. That this would be a ground of dismissal.
They have replied to it.
We replied to this plan.
20th,
But it was never posed that this is a ground of abuse of power under 6C. We are issuing this, therefore you are liable to be terminated. These 3 things were never met. And this is on record. This is on record. For this, my lord, I would just take your lordships to a single sentence in page 118. 118, 1. Kindly see 117, last para. It clarifies this position. Beyond doubt.
The
Volume
repetition.
1 of the
The
repetition.
repetition.
Volume 1, 117.
Page.
Page 117.
1
Yes.
Yes.
Yes. Here, my lord, kindly see what they say at the conclusion. 117 bottom, the last para. It is prima facie evidence of dereliction of duty. that you have acted without authority by initially posting additional charge of Suri Payal as member secretary in violation of 42F of the water prevent so and so and government guidance without approval of the government. Your behavior in hastily placing T minus chief environmental officer in official memorandum of the board without obtaining approval of government, even when request proposal submitted to you is pending government's review. Your act of, this is the operative portion of the notice. Your act of deliberately disregarding the rules and government guidelines and acting in an unauthorized manner is questionable. Therefore, you are requested to submit a reply and explanation within 1 week of receipt of this notice regarding a questionable and unauthorized performance. But nowhere do they say that this will be a ground for my termination or dismissal from the post of, a stigmatic dismissal from the post of chairman of pollution control. If they have not even stated this, then they issue a review notice. In none of these notices do they say that it is under 6C of the Water Act, it is a gross abuse of power, therefore you are liable to reply. But suddenly it is taken in the order of termination dated 31/5/2000, 31/5/35, 31/5/2024. This is number one. Therefore, my lord, the ruling of the Supreme Court, recent ruling of the Supreme Court on this point will apply, which I place before your lordships, annexure.
With my learned friend's permission, my lord. 118 last sentence. In case of failure, your explanation statement will consider nothing and future actions will be taken. It's clearly mentioned.
What further action, Lord? This must be seen in the light of the Supreme Court judgment, recent judgment, where even in a simple case of blacklisting, Supreme Court says the penalty that is supposed to be inflicted, the reasons for infliction must be stated in the show cause notice. This is at the show cause notice level, Lord, where the government is defaulting. And that too for a post as a post as important as a chairman appointed statutorily, a chairman of a pollution control board. That judgment, Lord, last time I referred just to the Supreme Court judgment. Just I will take your lordships to that judgment because principles under the judgment will apply. Therefore, that is one point. I'll just read that.
Continue.
Yes.
Which judgment you are relying?
Justice Nazir's judgment. Last time I pointed out.
You gave that judgment?
I gave that judgment. Just apt on the point, Lord, which will take out this allegation totally.
So all the three notices are issued in the final order?
Please, Lord. Yes.
All the three notices are mentioned in the final order?
Yes. In that, notice number part 2 and 3 of the allegation, that is notice 1 and 2 of their insinuation against me, there 2 Water Act 6E is not mentioned at all. It is a vague notice saying reply. That is taken in the final component of termination as part 2 and 3. So that goes. What remains is part 1. In part 1, Lord, before your lordships come next date, before the next date, I'll just summarize. In part 1, what they did, in the original notice dated after the division bench notice, they issued fresh allegations based on an August report of Mahadev. No doubt they say that it is enclosed with the report, investigation report. But they crystallized it into 9 allegations. These 9 allegations I replied. In the final order, part 1 of the order, almost 8 allegations out of 9, 7 allegations, they accept my reply. 2 allegations, they do not consider my answer. They simply say, no, you're liable. But they add about 20 more allegations post-notice. How could that be? Where was my opportunity to reply to that notice?
With my great respect, these are all in the air. Let him point out.
The manner in which the government, a secretary of the government dislodges a chairman of an institution, virtually usurping him and removing him. How could 20 allegations, insinuations be added post-notice? And where was my opportunity to reply?
My humble request.
And 7 are left.
My humble
No
request.
answer.
My humble request to my friend is what he's saying, let him point out from record.
I'll point out.
Not on general statement.
Last time, Honorable Learned AG was not there. when I pointed out, my lord. Next date, your lordship, specifically I'll point out how. They're from the record, because what is born out of record, we cannot state in any other way. And that is final. So they take these 20 allegations, my lord, 20 and more, and say this is gross abuse. But where was the opportunity to answer to those 20 points? That's where it is.
There is no decision on this, under this act.
Under this act, it is not there.
No, in fact, we look, that's why we went to Manipur.
But we'll make further steps.
Manipur section is perimeter.
I didn't take it. I didn't take it. Therefore, we went, that's the only division bench which we are able to get.
We'll see.
Yes.
When shall we keep? Tomorrow?
Tomorrow.
Tomorrow, what is it? Tomorrow, the matter is 2:30. Whenever you want.
Tomorrow.
Lordship, maybe mention item 45, Lordship. If Lordship asks, maybe mention item 45, Lordship. It's a child custody matter. The other side was to file a reply. A short date may be given, Lordship. They've not filed the reply till now.
Which one?
Item 45, Lordship.
40?
45.
55.
The other side had sought time to file the reply. They've taken 3 weeks' time. They've not filed any response also till now. So Lordship may either give them a last opportunity, subject to what your Lordship deems fit.
45.
The serial number
My lord,
89, my lord, serial number 89 was
2nd August. 2nd August.
I'm so
My lord,
grateful.
serial number
my lord,
27, my
89.
lord.
My lord, stay is granted is serial number 89, may be extended, my lord.
My
Serial
lord,
number 89.
serial number 27, IO may be extended, my lord.
My lord, serial number 47, my lord.
All interim orders wherever there, it will be extended.
My lord, serial number 47, my lords.
Yes.
My lord, serial number 47, my lords, I appear for the petitioner, my lords. The state has to file the objection, my lords. Kindly the short date may be fixed, my lords.
19th August.
Much obliged, my lords.
Serial number 61, interim order may kindly be
Will
extended.
be extended, all interim.
Serial number 29, my lord.
Serial number 8, a PL matter.
Two cases need to be dealing with the main petition. The different respondents in different ways. Case number 35,
What do you want?
dealing with the main petition. There are four
At the time of hearing will dealing, not now.
Serial number 78, my lord, second week of August. It's a year-old EIL matter.
Serial number 29.
Serial number 82.